little hearing room over at the other building on a Saturday night, and I had my little
Check, 1, 2.
and there was no way to get out.
Oh, no.
And there was no phone, and it was before we had cell phones.
Yeah.
And I ended up having to put my shoulder on the double doors and just break out. Saturday night, it was
Check, 1, 2.
not good. She was crying, and my sister-in-law, who I was showing the hearing notes to, was not impressed either.
Yeah, yeah.
Check 3, 4.
Check, 3, 4.
But the next week, we made sure we put a phone in that hearing.
Check, 1, 2.
She was crying, and my sister-in-law, who I was showing the hearing notes to, was not impressed either.
Check, 3, 4. Check, 3, 4.
Today is day 2 of the evidentiary hearing in file number EO-2024-0002. Again, my name is Judge Charles Hatcher. I will be presiding over this evidentiary hearing. We have staff witnesses coming up, and do we have any other business that we want to discuss before we get started?
Judge, I just wanted to put on the record, we did file an errata yesterday related to Brad Lutz's testimony in EFS. I don't know if you want to take that up, and I don't think we've actually had his testimony admitted, but at some point, we'd like to have that done.
I'm going to put a note on my desk to ask at the end of the hearing today, because I happened to overhear that not every council had checked EFS this morning. So I'll give everybody a little bit of time. I saw it, looks great. And at that point, I'll ask this afternoon, if we get no objections, then we move forward. We might feel that out, but I don't expect any.
Thank you.
Okay. Ms. Kerr, the floor is yours. Please call your first witness.
Okay, thank you. I'll call Sarah Lange.
Please raise your right hand. Do you solemnly swear or affirm that you will tell the whole truth during your testimony?
I do.
Thank you. Please have a seat. Your witness.
Thank you. Good morning.
Good morning.
Can you please state your name for the record and spell your last name, please?
Sarah L.K. Lange, Lange.
And by whom are you employed and what's your position?
I believe my position title is currently economist for the Missouri PSC staff in the Tariff Rate Design Division.
And have you prepared and filed testimony in this proceeding, specifically rebuttal testimony on December 15th, 2023, which has been pre-marked, I believe it's Exhibit 218, and there's confidential 218C.
Her rebuttal testimony is marked as 201.
Okay, so I'm sorry, it's 201.
Okay.
Okay.
Thank you.
yeah,
Sorry to
I
interrupt.
moved it. 201C and 201 and 201C.
I have, although similar to the discussion around Dr. Mark's testimony yesterday, my understanding is that that confidential designation is no longer required on the confidential version.
Okay. And do you have any changes or corrections to make to any of those documents?
I do. On page 5 at line 26, I referred to the importance of the customer usage information data for the fuel adjustment cost base factor. And so page 5, line 26, the word cost should be replaced with the word clause.
Okay. And other than that change, are there any other changes that you need to make to the document?
Not that I'm aware of.
And with that change, would, if I asked you the same questions, would your answers be the same or substantially the same as they?
Generally, there were items that Evergy raised in rebuttal that were not addressed, that if you asked me those same questions today, I would need to address those items raised in rebuttal. But as of the time I filed my rebuttal, that is accurate.
And those same answers are true and correct to the best of your knowledge and belief?
Yes, with that caveat.
Okay, thank you. So I offer exhibit, I guess we're just doing one exhibit 201 into evidence intended to the witness?
I think so, Mr. Kleiser. I think we're going to do just one. I need your attention because I'm going to circle back and punt Dr. Mark's testimony back to you. Would you please send me the cleaned up?
I thought that was coming.
Yes, I was all caught up in volunteering yesterday and trying to be helpful and realized that's going to be a lot easier for you. I would like to do the same with Ms. Lange's testimony. And I want to make sure I get a nod from the company. These, Dr. Marks and Ms. Lange's testimony will not include a confidential version and will include the numbers from BDL-1, right?
So it would just be the same testimony without the confidential designation around the numbers. I have no objection to that.
Okay, I just want to make sure we're all talking about the same thing. Awesome. Okay, we've done yours. Just email it to me. Let's do yours. You've heard the motion for Exhibit 201, one copy, public copy, being admitted onto the record. Are there any objections? Hearing none, it is so admitted. Just email me that the next week or so. Thank you.
Okay.
Your witness, thank you. Oh, and I will state for the record, we have the attendance of commissioners this morning. We have Chair Roop, we have Commissioner Holzman and Commissioner Hahn, and we have Commissioner Kolkmeyer. Thank you. I do expect Commissioner Coleman will be joining us in a little bit. I apologize, Ms. Kerr. Please go ahead.
It's okay. I tender the witness for cross.
Let me check my magic cheat sheet. That goes to cross-examination for Mr. Kleiser.
Permission to approach the witness.
Oh, thank you, sir.
And then, Your Honor, like I said, as a quick explanation, this should be a copy of Schedule BDL-1 that is attached to the testimony of Brad Lutz. I'm not asking this to be marked as an exhibit because it will be entered into the record with his testimony. I provided it now for ease of reference and to make sure everyone had a color copy. So wanted to make sure that was clear what I'm doing. All right. Good morning, Ms. Lange.
Good morning.
Would you happen to have a copy of Brad Lutz Schedule 1 in front of you?
I will accept your assertion this is an accurate representation, and yes, I conveniently do.
There we go. I'd like to walk through this with you to kind of get a better understanding exactly what staff's position is on each of the items. And based on the RLJ's comments at the beginning of the case, we're not going to refer to these as data requests. I think we'll refer to them as either stipulation items or data sets, whichever you feel more comfortable with, just so that we adhere to that comment by the judge. So let's get right into it. That first data set, number 1, that is obviously the biggest dollar item according to what the company says it would cost. You would agree with me on that, right?
I agree that's the biggest number on this page.
All right, so that's a good place to start, besides being number 1. Now, to begin with, you asked for quite a few different things in this data set, right?
Yes.
And are each and every one of those things equally important? Or do you believe each and every one of those is equally important?
Well, if you're the customer who's paying an extra couple grand a year, they're important to you. But these are items that relate to the specific price distinctions in Evergy's existing tariff sheets. So to say one is more important than the other, I can't say that, but definitely if I was going to do the sort of study that we envisioned when we entered into the stipulation, there are ones that I would prioritize.
Thank you. Actually, let me back up and let's clarify this. I think it was said yesterday, and I want to make sure that you agree, that these items in data set 1 are primarily focused on cost allocation. Is that an accurate statement?
Well, I mean, there's cost allocation, but there's also rate design. Frankly, I view these as more related to rate design than cost allocation. But I know that not everybody kind of observes those distinctions.
Now, staff has been doing rate design and cost allocation, since we're talking about both, in cases for quite a long time. Would you agree? Well, let's specify it, for as long as you've been employed.
Well, there was a phase from, I believe, 2005 to 2011-ish, where by stipulation, staff did not, no party did CCOS studies or rate modifications in Evergy rate cases, and that was pursuant to their, oh gosh, what was it called again? The IATAN rate plan. It had a longer name than that, but with that exception for Evergy, we have tried to do a CCOS in every case. We can't always do that. You have to do rate design to one extent or another in every rate case, because that's where compliance tariffs come from.
And really quick, just for the sake of our court reporter, you might have said it earlier, but CCOS is?
I'm sorry, class cost of service.
Thank you.
And typically, we leave out the word study, but class cost of service study.
And staff believes that the information it's requesting here is going to be necessary for class cost of service studies moving forward, correct, for Evergy?
Well, staff believes this information is necessary to ensure that the commission is approving rates that are just and reasonable, and that are not unjustly discriminatory or unduly preferential. Whether a literal study is done in every case versus checks of existing rate elements or other approaches is done can vary case to case. Data availability, staff time, those sorts of things all play into whether a full-blown CCOS study would be done in a given case.
Well, I guess what I'm trying to get at is the idea that there appears to be a difference in opinion between staff and the company about what information is necessary based on what's been done in the past. Now, do you believe that you can continue to rely on the information that you've relied on in the past to continue performing class cost of service studies?
No.
And is it because that information is out of date, or is there some other reason? Well, no, is it because that information is out of date?
That's one of the reasons. I mean, we have learned, this is going to sound like a non-answer, but it's really important. We learned in the Ameren case that, and it was Ameren's witness testifying about what he does for both utilities, and he's also the depreciation professional retained by Evergy. We learned in the Ameren case, Mr. Spanos testified more or less that the continuing property records do not align with what occurs in the field. The wording in one is getting at what is in the continuing property records. How much effort to throw into study of the continuing property records if we know it doesn't reflect what's in the field is a big question. So that is, I can't really answer your question without that context.
Fine. I'll actually move on. I think that there was conversation yesterday that there might be alternative ways to reach at least some of the information that's sought here, or potentially other information that can solve the same problem. Is that accurate?
Absolutely.
So coming to staff's position statement, because as I read it, staff's position statement was that you wanted the company to answer the DRs but not spend the money. Am I interpreting that correctly to try and say that you want to work with the company to reach an alternative resolution? Or how should I interpret that?
Well, the DRs we asked were trying to get at the plausibility of alternative ways of getting at the study information. So the data requests that are referenced in staff's position statement are asking for things like, can you do a survey of the line miles that operate at each voltage? You know, what would it cost to send an intern out into the field and look at 100 line transformers and, you know, report back what kind of installation, exists for those. That's the kind, we need more information from the company about what they can do for a given budget. And frankly, in retrospect, I should have asked them in the alternative. I should have gone through each of these items and said, if you had 10 grand to spend to study line transformers, what would you do? If you had 10 grand to study primary distribution costs and expenses by voltage, what would you do? And so on.
Both your answer now and what I heard, when Brad Lutz was testifying yesterday, really leads me to believe that there is a common ground that can be reached here. And one of the things that I don't understand about this case is the timeline. So I went and I actually looked it up this morning. So my understanding is that this case originates from your direct testimony in the last Evergy rate case. Is that fairly accurate?
There is additional background, but most directly, yes.
So I went and looked it up and I saw that as June 22nd, 2022 is when that was filed. You recall, is that fairly likely to be the accurate?
I have no reason to doubt your representation.
Okay, so then we had a stipulation in that case. That was September 30th, 2022. And I think that's in the record as part of the joint list of stipulation of facts. That stipulation said that the company needed to act by July 1. The company filed this case June 6th. What communication was there between staff and the company in the period between that stipulation in September 2022 and the filing of this case in June 6th?
Immediately, it was either concurrent with day before, day after signing the stipulation. I recall having a good discussion with Mr. Lutz about, we understand you don't have exactly this data in exactly this format. That's why we're giving you another 9 months to do this. So let's talk about what you can do and let us know, and we'll figure it out from there. And I do not recall hearing from Mr. Lutz on this subject again until either they filed the notice or we filed the complaint. I don't recall which came first.
All right, well, again, I was looking at this case, and it was filed June 6th. I found the joint proposed procedural schedule October 5th with an order filing it October 18th and direct testimony November 1st. I looked at when the staff was filing its data requests, and those appear to be hitting after direct testimony. So my question now becomes, from the period where this case initiated in June to, let's start with that October joint proposed procedural schedule, were you guys communicating then?
So Evergy had a workshop that really tangentially addressed some of where the company thinks it's heading with rate design, but it really did. It's attached to my testimony. It speaks for itself as to what was addressed, but that's the only discussion that I can think of that was anywhere close, other than that Evergy attended staff's workshops with Ameren. And I think some of those occurred during that timeline where much the same issues were being discussed. And, I think I called Mr. Lutz's attention to some of those issues as they were being discussed and said, that's the kind of thing we could look at with Evergy as well, as far as alternative data for existing rate disparities.
So if I understand that answer correctly, then is it safe to say that staff wasn't aware of the company's answer to the data request that you had raised back in your direct testimony in ER 2022-0129-0130 until they filed direct testimony in this case?
Well, no.
No.
So you just referred to them as data requests. I think you mean the stipulation provisions. To be clear, we did have data requests in the 129130 cases on this topic. One of them had a really useful response that had to do with kind of some sample customer-specific information data, or premise-specific information data, the sort of thing that's recovered in the facilities charge. The rest of them, I think, we asked for, hey, your CCOS had a split between primary and secondary distribution. Give us a calculation. And the response was that requires analysis and you can't compel us to perform it.
Given where you're sitting right now, do you feel like if you could turn back the clock, and do you think you could have reached a conclusion that would have worked if you guys had started talking well back before, maybe before they filed this case?
I mean, I think we would have just taken it to hearing in the rate case rather than just delayed the additional year.
Let's say that you had signed the stipulation, though. Do you think that you can get to a point with the company that you can get the information you need based on the testimony you've heard so far through this hearing?
I'm not really any more sure about what the company is and isn't willing to do today than I was last June. I was confused by a lot of statements yesterday.
All right, well, I'll leave that off for now. So I'm going to take up 2, 3, 4, and 5 at a moment here together. And the reason I'm going to do that is because when I was listening to your counsel give her opening statements, I could have sworn she said something to the effect that staff now believes those might be moot. I might not have heard that correctly, so I'll just ask. Are there any issues related to 2, 3, 4, or 5 that are now moot?
It depends. We're looking for clarity from the company. So 2, and I'll have to look really closely here so I don't reverse them. 2 refers to total number of customers on a rate schedule, whether or not they have AMI metering. 3 refers to total number of customers on a rate schedule that are AMI metered. So to the extent that there are now rate schedules where everyone is AMI metered, then there's nothing else to do there.
So these might be somewhat mooted already.
So either 2 or 3 should give us more or less the same answer or really, really close to the same answer. And I think Mr. Gu did say that yesterday as well. Now 4 is asking for how much energy was consumed by each rate schedule. So that's different than 2 and 3. You need them both to come up with usage per customer. But 2 and 3 are how many customers are you adding together? 4 is add them together. 5 is you can't add, if you have a customer that's metered at 240, 120 volt and a customer that's metered at 4 kV, you can't just add those together. If you have a customer that's measured at 34 kV, you can't just add those all together. So 5 relates to the adjustments that need to be made in order for those numbers to be added together, where you're not introducing errors of between 2.5% and 5% by adding together customers who are metered at different voltages. So what I understand from Mr. Gu is that when that is sent to the meter, when that is sent to the billing system, that information has already been adjusted out. Now, we had Mr. Bass's DR that we discussed with Mr. Gu yesterday, in which he stated in the last rate case he did just add those together without adjusting them for voltage. So you're going to have errors of 2 to 5%. So I'm not sure, because everything Mr. Gu says in her testimony is caveated by saying we'll do it to the extent we've done it in the past. So I'm more confused today than I've been on this case about what the company can actually do or not do with regard to providing this information.
I appreciate that answer, but locked into part of what you just said makes me believe, and correct me if I'm wrong, there is a possibility that the data request in 5 might already be included in what the company does, and therefore you wouldn't need to provide 5? That's a possibility?
That is a possibility, caveated by the company's response concerning this exact data in the case that arose in the stipulation, that they're fine adding together dissimilar voltage metered data.
So, based on that, there's a possibility that if you had a larger conversation with the company and cleared up some of this confusion, you might be able to effectively eliminate the costs associated with 5. Is that accurate or not?
Well, so staff asked this clarification in data requests, and those are the data requests that we refer to as saying we need the answer to those to give you a complete position on 2, 3, 4, and 5. So yes, a conversation would help, but I think we're at the point, and this is so technical and so detailed, that I think that conversations are probably a little bit past the point of usefulness, and we need to see specimen data and specimen calculations to understand what they can actually provide.
All right, fair enough. Let's move on to 6 then. Now, 6 was a bit of an odd one. The company flagged this. This is effectively just pointing out that the commission may design certain customer subsets for more granular study. And if such designations have been made, you would need to retain additional information for those subsets. Now, staff wasn't itself anticipating any particular designation of subsets, were they?
Examples that we had discussed with the company that came up in prior cases where the commission expressed interest in customers who receive LIHEAP or customers in a particular zip code, that sort of thing. Those were examples that I recall discussing, as this was a litigated issue or a putatively to be litigated issue in the last rate case. Those were examples I recall discussing with the company. We didn't have any in mind at the time, but just to be aware as they're setting up software that, if we're doing a lot of programming, let's get the capability we think we're going to need, not wait until it's too, imminent.
So,
I'm sorry, LIHEAP, and I believe it stands for Low Income Heating. I think Education and Assistance Program, but I'm not confident on the E.
I don't know either off the top of my head. So if I,
Energy Assistance Program, a voice from above,
so if I understand your position, what 6 is really asking for is effectively to have the company kind of future-proof, or at least think ahead as it's designing its programs in case the commission might want something like this in the future.
To be fair, recognizing we can't anticipate every scenario, but LIHEAP and zip code seem like good places to start.
7 and 8 appears that the company can already provide that. I don't think there's much we need to say on those two, unless there's some reason you think that there is a problem with 7 and 8.
Well, so 7 and 8. They have them on here as 7. Let me. So 7 and 8 are an issue when we get to. I guess it's 8CD. Again, he numbered these a little bit differently than I did. But so for purposes of a general rate proceeding, we're supposed to have access, we being staff, are supposed to be able to get access to that 36 months of data to look at customer impacts, study responses to weather, that kind of thing. If we're doing a more detailed study, it's not something I'd anticipate requesting every case, but the availability of that data to be delivered to staff on a 36-month basis is kind of intrinsic in what's on here as 7 and 8.
Okay. I'm going to move on, because again, I didn't think that 7 or 8 would be a problem. So I'm going to move on to, oh, I just now realized that there are 8Bs. I'm sorry, I was confusing. I meant 8A on the front page. I do apologize for that confusion. I realize now it was my fault. So flipping over to the other side of the schedule, page 2, let's take up 8B. So 8B is unique on this sheet. It's the only one with a green availability but a red deliverability, which leads me to believe that hopefully there's a way that you can resolve this just by figuring out how to deliver the information. So, in that box, Evergy has said, basically, as I read it, let me ask you this. Is my reading correct that says the problem here is the 15 minutes view of system peak?
I thought so until a data request response said they can't even do it on 30, and 30 is their, in Brad Lutz's testimony in rebuttal, in the rate case, he said Evergy said they could do this. They said they couldn't do it for residential. They may not be able to do it for all of SGS, but they said they could do this for the other commercial and industrial classes. And then in their testimony in this case, they can't. And so initially, I thought maybe we could address this. So Evergy West does its NCP demand charges and its facilities charges.
1 second, NCP,
Oh, I'm sorry, non-coincident peak.
please continue.
So currently, a lot of revenue recovery comes from the non-coincident peak of large customers, and large customers can include some fairly small customers. Around the clock. Evergy West assesses that based on the highest 15 minutes. Evergy Metro assesses that on the highest 30 minutes. So I asked in a data request to Mr. Lutz, okay, can we do 8B if we do 30 minutes for Evergy Metro? And I believe the response was, well, we haven't considered that, but we don't think we can. We still have the same answer that's in testimony.
I'm sorry, I got confused there. Did you just say that they are doing it currently, but they can't provide the data?
I'm sorry, their NCP currently is on 30 for Evergy West. I'm sorry, Evergy Metro. So if it was that the 15 minutes is the issue, that's how Evergy West already bills, which Mr. Lutz said in rebuttal in the rate case in response to the testimony that resulted in the stipulation. They can provide it, just not for residential and SGS. And now in this case, they've clawed that back. And this is an issue the industrials have brought up. This is an issue a bunch of jurisdictions are doing. Most of the co-ops in the state. Evergy's response on this issue is just legitimately confusing to me.
All right, I'll move on again. 8C. Now, if I understand 8C correctly, that refers back to 1. So I'm hoping that if you guys reach an alternative resolution to 1, that would resolve 8C. Would that be an accurate statement?
So I view 8C as being, kind of updates from time to time. We tend to look at big views of the distribution system every couple of decades. The last time it was really looked at and aligned with rates was in the 90s. So I view 8C as we're not going to do a full-blown distribution study in every case. We're not going to go through everything in one in every case. But maybe, we'll ask for, hey, could you give us an update on what your cost for, this type of conductor is? Can you give us an update on what your cost for this type of meter is? I view that as what 8C is speaking to.
I'm actually going to go off track here for just a moment because you brought up something that I wanted to get into. So staff is relying on a distribution study for Evergy that dates back to the 1990s currently. Is that accurate?
Well, it's not really a distribution study. It was an agreement among the staff, the industrials involved at that time, and KCPL about how to align each party's view of cost with what the rate structure is. So the rate structure was agreed to back in '96 and carried forward with, as Mr. Lutz said yesterday, changes made in cases. So it's not like there's a literal study that we say, here's how much it costs to, install a meter for a customer who's using, a big factory. It's that we said, we being staff 30 years ago, said, we agree with the company that if you have a meter of this size, you should be charged a customer charge of this size. If you have, facilities of this size, you should be charged a facilities charge of this price. That's what we have from the 90s. We don't have a literal distribution study. We have an agreement about how to price in a way that is not unduly preferential.
And what you said jogged my mind. That agreement, since that's the term you used, from 1996, that was the thing that was attempting to be brought in yesterday. Is that right?
Yes.
And so if I understand you correctly, I want to make sure I get this right. That thing has formed the sort of pathway from 1996 till today of how staff approaches class cost of service in Evergy cases with some modifications along the way. Is that accurate?
Well, so the modifications come in as the result of rate cases. But when staff looks at customer charges, those are the things we're trying to put in customer charges for Evergy. When staff looks at facilities charges, those are the things we're trying to put in facilities charges for Evergy. And that's why we need the information that's in item 1 about the relative costs of metering for customers of different sizes, the cost of facilities for customers of different sizes. And the big one is just the split between primary and secondary in terms of the cost of the distribution network system.
So your position is you need the things in item 1 to do what was set out in 1996? I'm confused.
The rate structure of Evergy and the rate structure of KCPL, which has since been pretty closely applied to Evergy West, includes certain elements. Those elements are priced differently based on customer characteristics. I can't sign my name on an affidavit saying that a rate result is just and not unduly discriminatory if I don't have some basis for why those prices are different based on those existing characteristics.
I think I'm beginning to understand it better. All right, well, you answered my question on 8C1. I need to be careful here because it's being broken down even further. 8C2 just references above, so I assume that we don't need to discuss that one. That's taken up.
Well, this is where timing is really important. So Evergy is months behind other Missouri electric utilities on providing usable billing data and usable load data in rate cases for staff to do an update period. And update periods, I think, are a feature fairly unique to Missouri, or at least Missouri led the way, is my understanding, in the use of update periods and true-ups to mitigate regulatory lag. With Evergy, we're coming into a case looking at the relationship between energy usage and weather for a period that's 18 months old before the case starts. And that's not terribly uncommon for a utility direct filing. What's unique with Evergy is the lag in what they can provide for staff to perform its update, which is a key tool to mitigating regulatory lag. And Kim Cox and Michael Stallman are going to be better to discuss that with.
I'll bring it up with them then, thank you. So again, 8C3, that's another one that the company has the available data and it thinks it can deliver it. So I take it there's probably no problems with that. Is that accurate?
No. So this is one I just find shocking, that the company says it's going to cost them 260 hours and $42,000 to do something they weren't going to do anyway. So the company routinely comes in with proposals that will change rate design for customers, that will change how customers are being charged and will have different impacts on different customers. So if the number needs to be something other than 100, and by the way, Evergy changed this request to say 100 total customers, not 100 per rate code, not even 100 per class. But if Evergy isn't looking at this, I would be really concerned with the utility in the year 2024 that is proposing any changes to rate design and not looking at impact sample customers.
I mean, you say that. Have you talked to other companies about this?
we get this from other companies.
So this information is something you already received from, let's say, Ameren, Missouri.
I believe Ameren gave me sample customer data in their last rate case, and they aren't even fully AMI yet.
What about Empire or Liberty, whichever name they're on?
I know when we've discussed this with Liberty, they've said it wouldn't be an issue to provide it. I don't recall, given the timing of the last rate case, if we did this or not.
What about 8C4 then? Is that one that we can at least say is resolved?
Sorry, I'm just making sure of the difference. Okay, so the difference between C3 and C4 is C3 says if you have more than 100 customers, give us 100 customers. So for example, some of the classes have, and some of the rate codes have far fewer than 100 customers. Some of them have 50 customers. So the difference between C3 is if it's a big class, give us 100 sample. If it's a class that has fewer than 100, give us everybody.
Okay, so in that case, I had assumed that all of your same comments regarding C3 would apply equally to C4.
Absolutely.
All right, thank you. That explains that. 8D, again, that's one of the C individual items above, so I'm hoping that that one doesn't have any concerns. Is that right?
You know, this is the one that I was jumping to when you asked about the earlier provision. So we addressed that when I
All right.
was, yeah.
And that brings us to 9. Now, yesterday I had an interesting conversation with Mr. Brad Lutz about 9. And my understanding from the company, based on that conversation, and the record will speak for itself on this, was that the company felt they wanted to have the issue litigated and that they would provide determinants for a coincident peak if that was something that the commission ordered in the future. Has the commission addressed coincident peak charge in past Evergy cases?
So in the last Evergy rate case, I mean, the order speaks for itself, but what happened in the last Evergy rate case is that MECG proposed on-peak demand charges, coincident peak demand charges. Staff proposed introduction of a time of use overlay, and Evergy said, we can't do this, we don't know how it's going to impact customers, and the commission agreed and said, we don't want to order this until we know how it's going to impact customers. So we're in a very strange loop here where we can't look at determinants until it's ordered, but we can't order it until we look at determinants. And I agree, I don't want to order something that we don't know what the charges would be, what the determinants are. That's a big problem. We don't want to do that. But that's why we need to look at determinants.
So, and I think you've already covered this, but just to make sure it's clear, staff says we need the information so we can get the determinants so we can examine it in a rate case, because in the last rate case, the commission said we can't order it absent the determinants. Is that accurate?
I think what the commission said is we can't order it because we don't know customer impacts and customers don't know what it would do to them, that sort of thing. And I mean, the order speaks for itself. I'm not trying to put a spin on it. But that's my recollection of how we got where we are on this issue.
Okay, and just to make sure that it's clear for the record, the information you're seeking here would be necessary to determine the customer impact of a coincident peak charge.
Yeah. And I mean, Mr. Lutz raises a fair point that we'd have to talk about what periods to study, and staff is asked in data requests, you know, what's your preferred period? And here are some periods for you to consider. And the response was, this would require analysis, and we aren't going to do it.
All right, so having gone through all 9 of these data sets as they're set out, and again, I don't want to paraphrase you too much, but looking at the prices here, I think that on 1, there was a conversation that we might be able to reach some type of alternative consideration. So,
I said in my rebuttal not to do what is on 1. I don't know how there's any confusion on the company's part at this point.
okay, so we'll just leave off 1 then. I'll just move on. The rest of these, and I'm going to do the math really quick here. 2 and 3 were mutually exclusive, is that right?
They'll be really, really close. Based on Mr. Lutz's testimony yesterday, it would only apply to certain residential customers, and, you know, it depends on how many that is, but it should be really, really close.
I'm going to just take 21,000 then for 2 and 3. And I'm just going to use their numbers just to keep this clean. If I add on 54,000 then for 4, 5 might be able to get taken care of, depending on the answers we seek. So I'm going to leave it out for a moment here. The next one I see coming up really is 8C2, 20,000. 8C3, 42,000. And 8C4, 40,000. If I just add up just those, and I don't know if you did the math yourself, I'm getting about 177,000 we're talking about. Does that seem like an accurate calculation of those? And
I accept your addition.
let's try and put that in perspective, actually. You know what? Evergy brought in retained an expert for this case, an outside expert. You're familiar with that, right?
I am aware of that, yes.
Mark and exhibit, this should be 304.
So marked?
This will be confidential. I will endeavor my best to avoid any discussion of confidential information. Ms. Lange, would you agree with me that this is a Evergy data response to OPC question 2000?
Yes.
And again, I stress, this is confidential information, so please move slowly to avoid saying anything in case we need to go in camera. I will prefer not to. Now, I believe the testimony of Mr. Riley identifies him as a partner at the firm of PwC or PricewaterhouseCoopers. In fact, I can cite you to the exact line if necessary, but will you agree with me for a moment that he's a partner?
I'd say that that testimony would speak for itself.
And if you turn to the page 2 of the attachment here, which actually, let's back up. This question that was posed to Evergy asked for the contract agreement between Evergy and PricewaterhouseCoopers. Would you agree with that?
Yes.
And the attachment is the contract agreement between PricewaterhouseCoopers and Evergy.
That's what it is labeled.
And if you turn to page 2 of that agreement, you'll see the price per hour for a partner level individual.
I see that.
And if we take Mr. Riley's word yesterday that he has worked some 100 hours at least on this case, again, moving slowly so that we do not violate confidentiality, if I multiply that 100 hours by the partner level, you would agree with me that Evergy has already spent quite a lot on this case compared to what it might otherwise have cost to enact the changes that it claims.
I am not comfortable answering that in public. Given that if 100 hours is the hours, that makes this a lot easier, I think, for us to avoid stating that by perhaps just introducing the exhibit.
You're right. Your Honor, I'll just move the introduction to the exhibit and try to take up the issue in briefing, assuming there's no objections.
You've heard the motion. Exhibit 304, confidential. Due to commission rules, there will be a public version that will be redacted in full. Are there any objections to the admission of Exhibit 304C? Hearing none, so admitted.
Right, that was the other one. All right, do you have a copy of your own testimony?
I hope. Sorry, I didn't reorganize my folder yesterday as well as I tried to do. It may take me a moment. I am not sure if I have it with me. If my attorney might happen to have an extra copy, that would probably move things along.
Do you have one, or I can lend her mine? Caroline,
have
do you
one.
have a copy?
I apologize. I suspect it is sitting on the copier, in fact, because I
think we have a copy coming to her.
thank you.
You have a copy then?
I do now.
All right, turning to page 60, if you would be so kind.
Forgot it was this long. My apologies to all involved. Yes.
So at line 22, you identify, well, actually, it begins on line 21 and then continued on for several more lines and several more pages. Page 60? Oh, she just has the one testimony, the rebuttal, doesn't she? Yes, from this case. Yes. You discussed the fact that you had previously outlined the staff's proposed rate modernization plan as part of it, case number identified EW 2017-0245. Is that accurate?
That's what it says.
Now, during the opening of Evergy Council, they identified that staff's, well, they identified what they characterize as staff's long-term rate plan vision for the future. Notwithstanding that characterization, they stated basically that this issue has never been put before the commission, has never been approved, or never been identified as policy of the commission. You would agree with me that staff's rate modernization plan, at least in part, was laid out in part of this docket, as you identify in your testimony, correct?
I have summarized or included this statement in, I think, every piece of rate, every rate design case I've filed since this docket, since the EW docket occurred. And we're open and eager to get feedback on modifications to, you know, just respond to changes in real time.
And with regard to it, as it appeared in that case, EW 2017-0245, that was where you were identifying what the commission could consider as certain rate structures and rate designs to enhance customer responsiveness to DER or demand distributed energy resource opportunities. Is that accurate?
It is. We tried to be more comprehensive than that. In part, the concepts of the continuous rate design element in particular was included in response to this exact situation we're in here today, where utilities have information, but they don't have it by rate code, they don't have it by rate class. So that element of it is more of a recognition of utility data limitations and less directly addressing the DER problem, but they fit together, so it kind of had to be comprehensive and involve both.
Marketing Exhibit 305.
So marked.
Sure.
Ms. Lange, would you agree with me that this is the commission's filed response to staff's report regarding distributed energy resources that was filed in same case, EW 2017-0245?
That's what it's labeled.
And you would agree with me, if you read it carefully to yourself, that it identifies staff's recommendations beginning in the paragraph, second paragraph of page 1, continuing on to page 2, and includes specifically at item number 4, the commission considers certain rate structures and rate design to enhance customer responsiveness to DER opportunities by providing appropriate price signals to consumers and revenue recovery for utilities.
Was there a question?
You would agree with me that that's predominantly what it says?
Yeah, I think you read item 4 word for word.
And you would agree with me that beginning at the top of the next paragraph, it states that the commission accepts the recommendations offered by. I'll try my best, I'm sorry. you would agree with me that beginning at the first full paragraph of page 2, it reads, "The commission accepts the recommendations offered by staff and determines that they promote good public policy."
That's the first half of that sentence, yes.
I'll go ahead and read the rest of it, just for the sake of completeness. "And that it would be advisable to further consider the specific merits of each inappropriate case where the impacted parties will have an opportunity to be heard." Based on that language, would you not agree with me that the commission has, at least in the past, identified that it believes it is good public policy for staff to pursue the rate modernization recommendations that it outlined in this docket, in its report?
So part of the staff recommendation in the report included being responsive to what happens between now and then. You know, at the time that this was done, Evergy was the only utility with AMI data, or with AMI meters at this point. All of the electric utilities are fully or nearly fully deployed. And things have happened with ARCs that changed some things. ARCs, I'm going to get the acronym wrong, but referring to aggregating of demand response at a RTO level. So with the caveat that flexibility and responsiveness to the situation on the ground was included in the staff recommendation, yes.
And in addition to that, it is my understanding, and I want you to correct me if I'm wrong, that the staff recommendations here in this case are predominantly being drawn from recommendations by the Regulatory Assistance Program, or RAP. Is that accurate?
Staff's recommendations in this case are just about the commission ordering this docket to stay open to get information.
Is the staff's rate modernization plan in part reflecting the recommendations by the Regulatory Assistance Program?
Here's where Missouri frankly led a bit. While Mr. Lazar, I believe, was involved, I'm going to get which of the RAP professionals were involved in the Missouri docket. I think that, and I'm not taking pride of authorship here, it's going to sound like it, but I'm not. I think that staff's, what we laid out in EW 2017, I think that actually came before RAP came out with the rate design manual, which I believe was in 2019. It is consistent with that. We had a number of discussions with professionals from RAP who came in and actually conducted the workshop. The bulk of the report in EW 2017-0245 is actually just summaries of the presentations of the various utilities and of the RAP professionals. LaBelle, it was Mark LaBelle, I believe, not Lazar. I hope I can. And I apologize to both of them for confusing them. I believe it's MARC for Mark LaBelle is capital L-A, capital B-E-L. And Lazar is, I believe, L-A-Z-A-R, I believe.
And the bench will add, while we're taking just a second, ARC, A-R-C, is aggregator of retail customers.
I appreciate that, Judge.
And finally, would you agree with me that the policies that staff has pursued as part of its rate design structure are consistent with what the commission has adopted from PURPA standards? Let me spell that out. Public Utility Regulatory Policy Act of 1978 that it has adopted in the past.
Yeah, and that's huge. And I apologize. I should have addressed that in my rebuttal. Well, actually, I guess the request of Evergy to ignore class cost of service didn't come in until rebuttal. But yeah, I mean, this commission is bound to address the requirements of PURPA 1978, which includes cost of service related components and justification of components such as declining block. And it it ordered, there are commission orders binding the commission going forward about how class cost of service elements need to be addressed. Now, those are second nature to staff, and I frankly don't even think about them because they're fairly obvious constructs. But if we aren't studying and ensuring that those relationships that cause price differences to similarly situated customers, if we're not making sure that those are reasonable, we're going to be violating federal law in a hurry.
And just to clarify, the information that you're seeking as part of this case is necessary, you believe, to achieve that end and avoid violating federal law?
To the extent that those price disparities exist in a tariff, yes.
Thank you very much for your time. I have no further questions at this time.
Thank you. We'll go to the company for cross-exam.
Thank you, Judge. Good morning.
Hey, good morning.
I hope you had a good evening. I've tried to shorten my cross quite a bit, so I hope we can get through this fairly quickly. Do you have a copy of your testimony in front of you now?
I do now.
Is it your understanding that Evergy does not keep plan accounts or expense accounts that are differentiated by rate code or voltage level?
That's been my understanding since 2006, yes.
Okay, so you've always known that, even when you asked the first set of data, is that right? For the first set of data in this case?
Well, that's why the recommendation was made, is to develop information that we know doesn't just exist. If it just existed, we wouldn't need to ask for it.
Okay, so you knew whenever you asked the first set of data that data didn't exist, right? Is that what you're saying?
Well, there's a lot of things, there's a lot of separate items in item 1. Is that, you're talking about stipulation item 1?
Yes, I am, and I'm trying to clarify what you just testified to. That you knew when you asked that for that information that it didn't exist.
Well, I'm sorry, I don't understand the question.
Okay, let me just go on a little bit. You don't disagree with Mr. Lutz when he testified that Evergy does not keep plant accounts or expense accounts by voltage level, right?
I agree, Evergy doesn't do that. That's why we recommended that it be done and why we pursued a stipulation with Evergy that they do it.
Okay. And you agree with him that the company does not keep plant accounts or expense accounts by rate code either, right?
Could you say that again?
Well, you agree with Mr. Lutz that Evergy does not keep plant accounts or expense accounts by rate code or by voltage level for their normal operations, right?
Well, they do with regard to distribution versus transmission versus certain sub-transmission accounts.
So you do disagree with Mr. Lutz when he testified that they don't keep it by voltage level and by rate code?
If you're lumping everything in item 1 together, I think the answer to that question is I agree that Evergy does not do already exactly what is in item 1, which is why we recommended in the last rate case and possibly others that they do a study to estimate these costs in the manner reflected, because that's what their rate schedules desperately charge customers.
Okay, I'm just trying to understand where our differences are. So you do disagree with Mr. Lutz to that extent?
If you could point me to what you're referring to, Mr. Lutz, as having said, I'm a little bit I'm lost. Can we
Okay,
start
well,
over?
the record was going to reflect what he said yesterday, so let's move on. But would you turn to page 32 of your rebuttal testimony?
I'm there.
Okay, let's look at line 18, where you say the information is relevant to rate design under Evergy's existing rate structures And it's also relevant to staff's recommended rate modernization. Is that correct?
I believe you read that accurately.
Now, I believe you testified, and I just want to make sure it's on the record, that you have presented your views about rate modernization to Evergy and other stakeholders in the rate modernization discussions that were held last summer.
Could you state that again? When you say last summer, I'm not sure what you mean.
August 28th, 2023.
Was that the date of the Evergy presentation or the date of the staff presentation?
That was the date of the staff presentation.
I provided a summary view, yes.
Okay. Judge, I'd like to have a exhibit marked.
Go ahead.
And I don't recall my number.
You, sir, are on 7. It'll be Exhibit 7.
Coming up one short. Maybe this is staff. Sure. I thought you were going to-
I have an extra if we need.
Ms. Lange, does this document appear to be the PowerPoint presentation that you presented to Evergy and other interested parties in those discussions with Evergy?
If you're representing that you've accurately reproduced it, it does.
I did the best I could. I hope I did. Did you have a meeting on August 28th, 2023, where you presented this PowerPoint to the company and interested stakeholders?
I believe so.
The company and staff have actually had 2 meetings regarding rate modernization, one on August 9th and a second meeting on August 28th. Is that your recollection?
If I recall correctly, the first one was on a date that I had indicated to Evergy I wasn't available, and so I'm not actually certain of the date of that. It was conducted while I was on vacation.
I may have misunderstood your testimony, but I thought you said you attached the Evergy PowerPoint to your testimony. Is that what you said?
Again, this is all sort of running together. I'm confident there was a meeting that Evergy scheduled while I was on vacation. I don't recall if it was that or a different one, but I did attach the PowerPoint that I received later.
To your testimony in this case?
Yes,
Would you point that to me?
it should have been attached, I'll say. I was actually just flipping and trying to see if it was on here, and I'm hoping that it's just the version that I have didn't have it attached.
Could you be mistaken in that you actually attached it to the staff complaint that you filed against Evergy for not holding rate modernization discussions?
That could be. We have a lot of Evergy cases in right now.
Yeah, that complaint case covers several topics too, doesn't it?
It does.
Judge, I'd move for the admission of number 7. I'd move for the admission of Exhibit 7.
Thank you, Mr. Fisher. I was just waiting to catch Ms. Kerr's attention before I start my very fast question. Are there any objections to Exhibit 7? Hearing none, so admitted.
Let's turn to the second slide on Exhibit 7. There it states, this discussion is intended to be generally applicable to all Missouri investor-owned utilities, but may not apply to the particular facts and circumstances of each regulated utility. In particular, the availability of information to reasonably design facility charges is expected to vary. Is that right?
You appear to have read that accurately.
Okay, and you agree with that, right?
I do.
Now, are the residential rate structures and the non-residential rate structures that are contained in that PowerPoint your proposals for a path forward for future rate cases and rate design cases in Missouri?
So proposal is not a good word.
Okay, what's the right word?
Well, the right word is we had a meeting to discuss things, and so we outlined options. In particular, the way that I addressed on-peak demand charge versus, I'm sorry, in particular in this presentation, as I recall, the way that I wrote this, the slides confused participants as to the use of on-peak demand charges. So that rate structure element, definitely, I should have, I didn't write it clear enough. I accept that. Sorry.
Well, so I'm just following up on your comment. This wasn't a proposal. What was it?
It was a discussion. So we're aware that Evergy wants to do something they call bright lines. We're not aware of what that is. So we being staff, were addressing areas to consider. Because if there's two issues when you think about where to go with rates. It's if we had all of the information today, what would we do if customer impact wasn't a consideration? And it's what do we do to get where we would like to be based on what we know today, and based on being reasonable and cognizant of customer impacts.
Okay.
So I would love for this meeting to have resulted in a robust discussion of what Evergy would like, which of these we're eye to eye on, which of these for them are from their perspective a heck no. And unfortunately that didn't occur. So we don't have a concrete proposal because we need utility feedback. We need customer feedback. We need actual information to understand what is and isn't practical.
Didn't you testify, though, there was a meeting where Evergy did give a staff a presentation on their rate modernization on August the 9th?
And that didn't address commercial and industrial. That addressed ideas like subscription pricing and other sort of add-on tariff programs that Evergy has been throwing into rate cases for the last decade-ish.
And then we had a separate meeting on August 28th where you presented this PowerPoint, correct?
Yes.
And did Evergy ever say that's the end of conversations?
I haven't heard anything more from Evergy, and they're filing a rate case in a couple of weeks.
They didn't say that they were not interested in talking further, right?
Objection calls for speculation.
Overruled.
I'm sorry, what was the question? Did
I was-
Brad Lutz literally say, I never want to speak a word about this in the future? No, of course not.
But staff did file a complaint requesting more conversations, correct? Is that what that complaint is about?
The complaint speaks for itself, and I'm not clear at sitting here today the timeline of when that was filed.
It was filed 2 weeks, I think, after our meeting on August 28th. Is that your recollection?
So you're referring to Evergy's failure to conduct a meeting within 180 days to solicit and receive feedback?
Right.
Correct. 180 days were gone, and no conversations that occurred after that point
Well, on that
would
point,
change that.
is it correct that we didn't make 180, we made 190? Is that what happened?
I'm sorry, are we addressing the relevance of staff's?
Oh, I'm asking you whether we had a conversation 190 days after the tariffs were in effect. That was the first meeting,
A
correct?
conversation about what?
Rate modernization, that whenever the company presented its rate modernization proposal.
The company didn't present what I would consider a rate modernization proposal. The company presented a description of add-on tariffs such as subscriber tariffs and buffet-style pricing.
And that's the PowerPoint that you attached to the staff's complaint, right?
I don't have that in front of me today, I don't recall.
Okay, well, I can do that. Well, let me go back to that. I'll give you a copy of that in a minute.
Really quick, Your Honor, while we're discussing it, what is the number on the complaint case, just for
It's
the record?
EC, if Judge, I can give it to him if he'd like. It's EC 2024-0092. Oh, that's all right. Let's just go to the bottom of slide 2. there it states, the views presented in this document are those of Sarah L.K. Lange and are not presented as reflexive of the views of, at this time, of staff, the commission, or of any particular commissioner. Is that right?
That's what it says.
And is that disclaimer correct?
I don't know what you mean by correct.
Well, I mean, I think that reflexive may be the wrong word, but is it correct that the views presented in that document are your views and are not reflective of the views of staff, the commission, or any particular commissioner?
That's what it says, yeah.
Okay, so you don't disagree with that?
Objection. The document speaks for itself.
Okay, I'll move on.
I would like a straight answer.
I mean, I'll be as direct as I can. I don't speak for the commission unless the commission has ordered me to speak for the commission. And I think I've used this disclaimer on every presentation I've ever given, if for no other reason than if I change a font color, I'm not going to waste staff time to run that back by division directors. I don't think this is inconsistent with staff's position, if that's helpful. But I'm not purporting to speak for the commission unless the commission orders me to speak for them.
Thank you.
So then would it be correct to say that the commission or any individual commissioner has not approved the, whatever you called it, the idea, the proposals that are included in your rate modernization proposal in your PowerPoint?
This PowerPoint was not reviewed by the commission, nor was it presented to the commission.
Was it presented to other staff members?
Yes,
Okay. Do you have, well, let me ask you this. Is the cost of creating and preparing information a factor in considering whether we should go forward adopting the rate proposals that are discussed in your PowerPoint?
could you say that again? There were a lot of parts there.
Okay, well, is the cost of creating and preparing the information that would be required to implement your rate proposals in the modernization PowerPoint, is that a factor to be considered when deciding whether to pursue your proposed, what I called your long-term vision for rate design?
I wouldn't agree to the long-term vision characterization, but that would cost of implementation, feasibility of implementation. Yeah, those are obviously things that we would consider, and that's why we don't have a concrete, we're in no way trying to dictate what rates should look like 20 years from now. We're saying here are the things that we're looking at.
Okay. Do you happen to have a copy of the staff position statement in this case?
I hope so. Again, with my caveat that I apparently screwed up my folder yesterday and also failed to grab what I reprinted this morning.
I have a copy if you don't.
That'd be great.
Okay, let me just give you mine, if that'd be all right, Judge?
Did we want to admit this? Just so we don't, the presentation that you'd offered.
I think it's already.
Okay. What was the number on that? 7. Thank you.
I marked the area I'm going to ask you about, so make it easier. That's a copy of staff's position statement, is that right?
That's what you represent it to be, yes.
Would you turn to the first issue on page 2 where the question is asked, what is Evergy, Missouri Metro and Evergy, Missouri West estimate for the cost to provide line transformer costs and expenses by rate code? You see that question?
I do.
At the very bottom of that, there's a sentence that carries over to page 3 of the staff's position statement, and it states, and I think I've highlighted it, it would be imprudent to expend the lump sum estimate provided in attachment BLD 1. Is that what it says?
Absolutely, that's what it says.
Okay, good. And if I look at the position statements related to 1A, 2A, 3A, 4A, 5A, and 6A, I'll find a similar statement, right?
That sounds about right. I'm not sure exactly where it cut off, recognizing that we don't actually have cost estimates from Evergy for each of these items, so we're referring to the lump sum.
Right, so.
Could be that pursuit of an individual item from the list would be reasonable, but we don't have that evidence in this case.
Well, do you agree that with staff's position statement that it would be imprudent for Evergy to spend 80 to $100 million to create and produce the data requested in the first set of data?
If that's what it costs to produce it, as I said in my rebuttal testimony, that's not reasonable. No, don't do that. Please, don't do that.
And I think I understood you to say, you made that very clear in your testimony, that you didn't want the company to spend 80 to $100 million on the first set of data in your testimony.
I want that to be as clear as I possibly can,
Would you
yes.
show me exactly where you're talking about in your testimony that you said that we shouldn't be spending that much money?
It's under the heading Recommended Path Forward.
And what page are you on?
I'm getting there, Mr. Fisher.
I'm sorry.
I'm not as quick as you may be with handling papers.
I am sorry. I don't want to rush you. I'm sorry.
If we could take the temperature down, please.
I would appreciate that, Judge.
So would I, Judge. I appreciate it.
I'm talking to both of you. Thank you. No more extra comments.
So, under the heading Recommended Path Forward. on
Page number, please.
It's page 17.
Thank you.
I state, Evergy failed to provide cost estimates for the items of distribution data, and to date, Evergy has refused in discovery to cooperate with staff requests to establish the relative costs of provision to distribution data. The Commission should leave this docket open as a repository for discovery and for the resolution of potential discovery disputes as staff proceeds to request information to complete a distribution study. I proceed to provide examples.
Okay, so that's where the company should have concluded that you agreed that it'd be imprudent to spend the money on the first set of data, right?
Well, my recommended path forward didn't say, order the company to expend $100 million. It said, do this instead.
Why didn't the staff's testimony and rebuttal just say that it would be imprudent to spend the money like you said in your position statement?
At that point, we had outstanding discovery disputes to get line-by-line information concerning the items in item 1, rather than a lump sum information.
Well, just so the record is clear, staff does not now recommend to the commission that the commission order Evergy to produce the data in the first set of data, correct?
Could you say that again? I apologize.
I'm trying to be clear if I can, but staff does not now recommend to the commission that the commission order Evergy to produce the data that was included in the set number 1, or what Mr. Lutz says is DR number 1?
At a cost of $100 million?
Yes.
No, absolutely not.
Good. Now, your rebuttal testimony doesn't include estimates from staff for the creation and production of that data that you're requesting in any of the DRs or any sets of data, correct?
That's not what the stipulation addressed.
Well, I'm asking whether you included that in your testimony.
No, I wouldn't have included irrelevant information in my testimony.
Okay. Do you have the expertise on staff to make an independent estimate of what the cost would be for creating and producing that kind of data?
Which kind of data?
The kind of data you're requesting in this case?
There's a lot of different data in this case. That's,
Okay, do you have expertise? I guess I'm asking whether do you consider yourself an expert in estimating the cost of modifying a public utility computer system to implement new rate designs?
I don't, no one has requested that.
Okay, well, my question is, do you consider yourself, I guess, an expert in estimating the cost that it would take for Evergy to change its computer system and its accounting systems to produce this kind of data?
We aren't requesting that Evergy change its computer systems and its accounting data, but no, I'm not an expert in that.
Okay. Well, let me just ask you some broader questions, I guess. From your perspective, is it the role of the commission staff to be fair, objective, and unbiased?
I hate to put it this way, but unless the commission has ordered us to pursue a specific policy objective or some sort of, that's a very, very broad question. I'm not sure that I can answer it in the abstract. Our job is to provide a recommendation to the commission so that the commission follows its organic statutes.
Well, in balancing the interests of the consumers and public utility shareholders, do you try to follow the policies established by the commissioners through their previous orders?
Well, prior orders aren't legally binding, and conditions do change, but with those two very large caveats, yes, generally.
Well, so how do you decide when staff should advocate a position that differs substantially from the past practices that have been approved by the commission?
I can't answer that in the abstract, sir.
Okay. If a staff witness is recommending a policy that would cost a substantial sum of money to implement, is there a policy at staff that you need to get that checked by somebody or approved by someone on staff?
You use the word policy in that question, and that's what makes it not possible for me to answer it. I'm not sure what.
Well, I'm sorry, let me ask it a different way then. If a staff witness is recommending a policy that would cost a substantial sum of money to implement, who on staff would have to approve it before it's recommended to the commission?
All pre-filed testimony is run through the applicable division directors and staff counsel's office.
Okay, so that would include your testimony in this case, right?
Yes.
Okay. Let's turn to your recommended path forward. I think that starts on page 17 is where you've directed me to. And I'm looking at line 16 that it says, Evergy failed to provide cost estimates for items of distribution data, and to date, Evergy has refused in discovery to cooperate with staff requests to establish the relative costs of provision of distribution data.
I'm
Is that
sorry,
right?
what page are we on?
We're talking about page 17 at line 16.
Okay, thank you.
That's what you said, correct?
I think you read that accurately, but I'll defer to the words on the page.
Are you talking primarily about the distribution data that you requested in the very first set of data?
So this section, recommended path forward, has separate question and answers related to the different items. And so that's what the question is asking about, is the distribution data.
Okay. And then on line 18, it goes on to say that the commission should leave this docket open as a repository for discovery and for resolution of potential discovery disputes as staff proceeds to request information to complete a distribution system study. Is that right?
I believe you read that correctly.
Would you describe what you mean by a distribution system study?
Sure. Getting information dependent on what information is available. And I do think this would probably involve the sort of discussion with distribution engineers that the company is able to do when it performs a CCOS. But the questions that I have in mind are largely in the data requests that were submitted in this case, and those would be things like how many miles of overhead line operate at what voltage? How many miles of underground line operate at what voltage? For secondary circuits, do you have one big line transformer at the end typically? You know, when you use the phrase secondary circuits, are those operating at 240, 120 volt, or are those operating at 4 kV, 12 kV? That's the kind of information that, frankly, I tried to ask the data requests in this case as clear as I could to get answers to those questions. But in absence of that, that's the information that I need to try to figure out how to keep the current prices in the current Evergy rate structure just and reasonable.
Has the commission requested staff complete a distribution study for Evergy?
I think it depends on how you read that report in order. And I think that the instruction we got in Ameren, where the commission said we can't use anybody's CCOS studies because it's on bad data, I sure take that as saying get data to do a good CCOS study. I don't think they use those words, but that's how I interpret it.
Ms. Lange, you've been around a long time. Do you recall any case where the commission just said, this is the best class cost of service study and we're going to use it to set the exact rates?
To set exact rates? No,
To set rates?
To set rates? There are cases, yeah.
A lot more, though, that don't adopt a specific class cost of service study as the only way to set the rate, right? We spread it across the board. We do lots of things, but we don't necessarily say that it's going to be based only on this class cost of service study.
Okay, I got the second half of the question. Could you repeat the first half
I'll
again?
withdraw it. It was a little convoluted. How much do you believe the distribution study will cost to complete?
As I said earlier, in retrospect, I wish I would have said for each of these items, what can you do for 10 grand each? I haven't had that approved by the division directors, but based on prior conversations, I think that if we devoted a couple hundred worker hours to this at a cost of 40 to 50,000, that would be consistent. And Mr. Bush, if I'm out of line on that, too late, I guess. But to me, that seems reasonable in light of knowing just what it costs to do anything with a large organization and a large amount of data.
Would you do that in-house or would you hire an outside consultant?
Well, the nature of this is almost that it has to be in-house. And the sort of conversations we need to be having at this point aren't with people, no offense to Mr. Lutz, I highly respect Mr. Lutz. Mr. Lutz would need to be in the room, but, you know, we need to be having these conversations with, you know, a handful of distribution workers. And that's the sort of thing that Evergy represents it does when it prepares its class cost of service. Is it says, well, we talked to our distribution engineers and here's what they said we should do for polls. We don't get that opportunity and we need it.
Let me ask you this question. You mentioned the division directors. Have any of the division directors suggested to you that you need to be doing a distribution study for the utilities?
They approved this testimony.
I'm asking whether they ask you to do a distribution study.
Objection.
Grounds?
It's speculation.
Overruled?
Yeah, I mean, this conversation has been going on. There was a lot of pushback on my testimony to say we can't do a distribution study in this case, or we can't, you know, don't use any of these class cost of service studies because of concern that staff has to provide a class cost of service study at a certain point. And what could I do to get better data to provide a reliable study? That was a big topic of conversation in
Okay.
these Evergy and Ameren rate cases.
If the commission leaves this docket open as a repository for discovery and for resolution of potential discovery disputes. Would you expect to be filing data requests similar to the ones you filed in this case?
I've thought a lot about this. And I've thought a lot listening to Mr. Lutz yesterday and a conversation I had with Mr. Lutz a week or two ago. What could we have done differently to have not effectively wasted a year and a half on this? I think what we need to do is instead of doing this in the form of data requests, instead of doing this in the form of EFIS, things that are not visible to the commission, let's just air it out. Let's either have a hearing where Evergy provides distribution personnel. Let's do it in the form of filings rather than, the back half of EFIS. Let's just ask the questions, and Evergy can either answer them or say, here's the question you should ask instead. And frankly, I hope there's some where Evergy says, here's the question you could ask instead, because they have better access to this information. And again, make the big issue in this case is it really about finger quote secondary, finger quote primary, or is it about 120 kV, 240 kV versus 12 kV?
Well, let's talk about this case. In this case, and I think you mentioned it yesterday, you filed about 200 data requests for both companies in this docket, right?
The numbers speak for themselves. I think it was 132 unique.
Okay, well, there were 185, and then you followed up. There were around 200 total, I think. Would you agree with that? Whatever, it doesn't matter. You filed a lot of data requests in this case, right?
A lot is relative. I mean, this issue was pushed out of the rate case because it was so data intensive. So, I mean, I asked the right amount for the subject matter.
Okay, and you asked that those data requests be turned around in 10 days, right?
I think the company agreed to that,
We did.
and not all data requests were provided within 10 days. I believe every single data request was objected to.
Well, in some cases, you ask for 10 years' worth of data on numerous plan accounts, right?
I did. I asked for the work papers for your Fork Farm 1s for 10 years for the distribution plan account so I could prioritize which accounts merited further study and which accounts were showing slow enough growth or were small enough balances that they were lower priority.
And I don't really want to burden the record with the list of all of data requests where you asked for 10 years' worth of accounts, but would you agree it covered an awful lot of distribution plan?
It covered the distribution plan, yes.
Yeah.
There are, I think, 12 distribution accounts.
Yeah, and there are numerous DRs asking for 10 years' worth of data. I think it's all reflected in our motion, in our response to the motion to compel, so I won't go through that on the record, but, now.
We have a question.
Yeah, there's one coming. I'm sorry. On page 18 at line 2, you state, staff recommends this docket be used as a means to resolve areas where Evergy asserts that it cannot provide requested data because production of this data would require Evergy to perform additional analysis. Is that right?
That is what it says, and that is my recommendation.
So is it correct that staff's recommending that this docket remain open so that Evergy, or so that staff could request Evergy perform analysis in areas where the data or the analysis does not exist?
Well, I think Evergy's testimony from the time of Mr. Lutz's rebuttal in the 129 case is that none of this exists. So, obviously, yes, Evergy's position is that none of this exists, or we wouldn't have entered a stipulation.
And this wouldn't be tied to a particular proceeding, or not a rate proceeding, it would be open-ended?
I'm happy tying it to the concept of, now Mr. Lubert has a separate recommendation, but this recommendation concerning distribution data, I would love for us to either have common ground or agree on a set of alternatives that maybe we have one position, the company has another, perhaps MECG and OPC have a third and fourth, but where we could get that data straightened out and be done with it for another decade or two.
Well, my question was more about what proceeding. It would be an open-ended proceeding, just whenever you wanted to request the data, you could do that. It wouldn't
And
be tied to like our next rate case or anything else. It would just be an open-ended, or
I-
perhaps it would continue to keep this docket open. Is that what you're suggesting?
Yeah, that's what I just testified. That the idea would be that we come up with common ground, recognizing agreement to disagree on these price components that are in Evergy's existing rate structure.
Well, so if the commission accepts your recommendation to leave the docket open, would you anticipate filing motions to compel like staff filed in this case if we didn't answer something to your liking?
Well, as I said, my
Objection, asking for legal analysis.
That does seem a little speculative, Mr. Fisher.
Okay, well,
Can I answer? I already, it's what I said earlier. I think the better way to do it would be to file. We would file and say, hey, what can you give us for 10 grand? And Evergy could answer that.
well, let me ask, okay, Judge, I'll withdraw that. Let me ask you this question then. Let's assume that the staff files a motion to compel in that kind of a scenario. Would the regulatory law judge, and Judge Hatcher, somebody in his position, be expected to decide whether it's cost beneficial for the commission to order new data be created and produced?
Objection, same objection. He's asking for speculation and for legal analysis. She doesn't know what the judge would decide.
Judge, there's no legal analysis in that question.
Okay, she still can't testify as to what a judge would decide. That's not
I
her
didn't hear that was
position.
the question. What I heard was, would somebody in my position be the one making that decision?
That's right, that's the question.
You can answer. Objection overruled.
I would hope that if this goes forward, that the report and order addressing this phase of the EO docket, or at least, I guess, an interlocutory order addressing this phase of the EO docket, which, now that I say that, is probably the better way to do it. You'd have an interlocutory order setting out how this would be handled going forward, and then a final report and order, if necessary, which in an EO docket, I don't know that you need one, could draw any conclusions where the participants have had an opportunity to weigh in on the relative costs and benefits of proceeding with a given line of data acquisition, which is what's contemplated in the prior stipulation and agreement.
What criteria under that scenario, in your opinion, would the regulatory law judge use for deciding whether staff's data requests were cost beneficial?
I can't answer that. I would defer to my prior answer, I would actually say I hope it doesn't come to that. Based on Mr. Lutz's testimony yesterday, it seems to be across the board recognition that something needs to be done. The existing rate schedules have no real relationship to existing costs, so let's just figure something out.
Well, if we leave the docket open, as you were suggesting, isn't that the likely occurrence? We're going to have to come before a regulatory law judge to say, is it cost beneficial for us to create this new data that doesn't exist?
I hope not. I hope we can work it out.
Okay. Let's turn to page 40 of your rebuttal testimony. And at line 7, you state, Evergy's responses to staff data requests in this case reveal that Evergy did not undertake a good faith effort to comply with the commitments made in the 2022 stipulation and agreement. Is that correct?
That is correct.
Are you testifying today, as you sit here, that you do not believe Evergy is operating in good faith in this case?
This statement is much more specific than what you have just said. This is referring to the response to item 1, distribution expense information, where Evergy committed to provide item by item and instead provided a lump sum for all of those separate items. And that is what this statement is about.
Okay, so you're talking about all those data requests that were filed in this case, that we didn't do a good faith effort to answer those data requests?
That's not what this says. No, it's not what I'm saying.
Okay, what are you saying?
So I recall and I hope that this is laid out clearer in the written testimony, but I'll attempt to summarize here. So item 1 goes from things like meters, which are probably pretty easy to come up with cost by voltage, relatively speaking, all the way to things like extension costs, which may be reliant on very old documentation that may be very cost prohibitive and of relatively low benefit to getting greater information on. We asked in data requests, what is your estimate of the cost to provide line transformer costs and expenses by rate code? Separate data request, what is your estimate of the cost to provide primary distribution costs and expenses by voltage? And so on and so forth, separate data requests for each one. There was then a set of data requests where I thought, well, maybe they would do it by plant account. So I asked those same questions. What would it cost? What is your estimate of the cost to produce the estimate of the differentiation between primary voltage and secondary voltage in the overhead conductor account? Separate data requests. The underground conductor account, separate data requests. The poles account, because there's two ways you could get at it, right? You could look at it as what are the whole system costs, or going account by account, what are the costs?
Well,
And Evergy's response to that data request, to those data requests, was that's not what we did. We can't answer this. We don't have a cost estimate to do these items that are in item 1. That's what I am referring to in my testimony on page 40.
Okay, so you're saying that as you sit here today, Evergy did not undertake a good faith effort to comply with the commitments made in the 2022 stipulation and agreement.
This testimony refers to item 1.
It refers to commitments made in the 2022 stipulation and agreement, as I understand it.
The question
I think
says.
she's asked and answered. This
No,
question has been asked and answered.
Okay, I'm sorry, go ahead.
Waiting to see if your witness volunteers another answer on her own.
The question that he is reading an answer to what extent has Evergy's direct testimony in this case provided estimates of the cost to provide the distribution and expense information? Not all of the information in this case. It is very clear in the question what components I'm referring to. And I stand by that testimony. I don't think that Evergy complied with stipulation.
So you're talking about mostly the data request answers that we provided,
No, I'm talking,
or about the testimony we provided in this case?
If I could interject, I see a potential an honest miscommunication. I believe your question in your testimony limits it to distribution and expense information. However, the first sentence of your answer says the not good faith, and then the second sentence says specifically and returns back to the distribution. And then the end of your answer clarifies that question 1 of the Lange requests, request number 1, which was a combination request in your testimony, is now broken out into these. However, I think the miscommunication is in line 7, where it says, and I'm starting in the middle, and Evergy's responses to staff's little d data little r requests. I am confused whether we're referring to actual DRs or the Lange request number 1. Please go ahead.
May I clarify? This discussion is referring to stipulation provision 1. The data requests referred to in lines 7 and 8 are in fact little d data requests. Discovery promulgated in this case because Evergy didn't provide a work paper at all concerning BDL 1. So what I really hoped would happen, and what I was optimistic would happen, when I propounded discovery in this case related to this issue is that instead of it being a lump sum of 80 million to 110 million, we would get responses back from Evergy that said, we looked at it one of two ways, which is why I had to ask 2 sets of data requests. And we think figuring out meters is probably going to cost, $5,000 or some amount. That's what I hoped would happen, is that Evergy would effectively provide how they came to this 80 to 110 million value. Instead, what the responses to the discovery in this case, as referenced in line 7 and 8 said, is that that is the number. There are no work papers behind it. There is no report behind it. There is no verification of, well, we looked at each of these items separately, and here's what we think it would cost to do this and this and this in any kind of additive manner. And presumably going account by account would have been, so the way these are laid out in stipulation provision 1 is sort of concept by concept, but presumably to come up with how to calculate what they committed to provide in item 1, they would go account by account through those 12 distribution accounts.
Thank you, Judge. Should I continue? Thank you. Ms. Lange, is there another case pending before the commission? And I'm thinking of EC 2024-0092, where the staff is requesting the commission order the company to produce the same information that you're seeking in this case?
I don't recall whether or not there's a specific relief requested in the complaint case. Just direct testimony has not been filed in that case. I don't recall the relief requested, and to the extent that relief was requested, I believe it would be related to the filing of direct testimony.
Judge, could I approach the witness? I'd like to hand you a copy of the staff's amended complaint. And count 1 that deals with this data. There, in paragraph 15.
I'm sorry, you're not gonna be on.
There on paragraph 15, don't you include in the staff complaint all of the data that you've requested in this case?
It recites it. Again, I don't recall the relief requested in the complaint.
Since you've
if
got the
relief is requested.
Since you've got the document, would you turn to the wherefore clause and just read that?
I'm going to ask about the relevance here.
Well, I'm just pointing out the staff has another case pending that's asking for the same data that she's requested in this case.
Overruled.
The wherefore clause reads, staff praise the commission will give due note, and this is the wherefore clause concerning count 1, I'm sorry. Wherefore, staff praise the commission will give due notice to the respondents and, comma, after hearing, comma, paren 1, close paren, order that respondents forthwith comply with the stipulation order of October 2nd, 2022, comma, and the stipulation and agreement of August 30, 2022, comma, providing the above enumerated data to staff or explaining why it cannot, semicolon, paren 2, close paren, direct its general counsel to seek appropriate penalties from Evergy as authorized by law, semicolon, and grant such other and further relief as is just in the circumstances.
Okay, thank you. So would you agree that the staff is asking for that same data in that case that you're asking for in this case? The same enumerated data that you recited?
I'm not the attorney who prepared this
Can I
complaint.
object, asking for a legal conclusion?
I would
And
disagree
relevance?
that it's a legal conclusion, but if maybe Mr. Fisher could point to a paragraph
I'm just asking whether the enumerated data that they're asking be produced is the same enumerated data that she's requesting in this case.
I'm with you, and I'm anxious for an answer. However, the paragraph that you had her read doesn't say that.
Okay, maybe not.
So I'm really hopeful that,
Let me ask you that question then, just up straight up.
The question is the data list the same?
Yes.
I hope so, barring any type of graphical errors.
Okay, great. So assuming that the complaint case goes forward, we're going to be back in the hearing room for us to explain to you why we can't produce it and how much it would cost, right?
I can't answer that question.
Okay, that's fine. Staff also alleged in that staff amended complaint that Evergy violated the rate case order in other respects too. Is that right?
Objection.
yeah. Yeah, Mr. Fisher, your response?
I haven't heard what the basis of the objection is.
The relevance that has, and asking for a legal conclusion, and
Well, let me get more specific, I guess.
what does that have, I mean, what does that have to do with this case?
Let's let Mr. Fisher
Please.
continue.
I'll withdraw that question, Judge, and just ask, does the staff complaint also allege that Evergy did not meet with stakeholders to discuss rate modernization with 180 days of the tariff effective date of the last rate case?
Objection.
I'm going to allow it because we had the very brief discussion on the 180 versus the 190, which did raise the temperature in the room, and I would like to avoid that. However, we have already opened that door. I would prefer to keep it short. I get the point, but objection overruled.
So to clarify, the issue is a lot less with the 10 days difference and a lot more with the content of the presentation. Does that answer your question? And that's what the issue is addressed in the complaint, as I recall.
Well, that wasn't my question, but that's okay. It's not so much about the 10 days that we were late, but it's the fact that we didn't have additional conversations about rate modernization.
The complaint is the complaint. From my personal perspective, if we had met at 190 days and had a good conversation about what the commission directed that conversation to be, personally, I wouldn't have had a problem with it.
Let me ask you a question I asked you earlier. Do you know, did Evergy ever indicate to the staff that they were unwilling to continue rate modernization discussions?
Again, I don't think Mr. Lutz, told me to never talk to him again, but no fruitful discussions have occurred to get eye to eye with what Evergy's Bright Lines proposal is. And by Bright Lines, I'm referring to how Evergy has termed its view of rate modernization. But we have not had productive discussions, or I should say, we have not had meaningful discussions from Evergy since the last rate case, if not before, about what Evergy wants to do with its non-residential rates.
Or since the staff filed its complaint, right?
No, we had a meeting, we had the staff meeting after that. Again, the timelines are fuzzy to me. It's, the last 14 years have been a blur at this point with rate case
Right, well,
activity, but
The record will reflect those dates, so we don't need to go there. I think it was 2 weeks after the last conversation. But I appreciate your candid responses. I apologize if I turned up the heat at any point, but that's all the questions I have.
Thank you, Mr. Fisher.
Real quick, it was flagged to my attention that I did not move to admit OPC 305, and I wanted to take a moment to do that before we got too far afield. Apologies to interrupt the order.
You're fine.
That would be the commission's response to staff report regarding distributed energy resources filed April 18, 2018 in case EW 2017-0245, which again I have marked as OPC Exhibit 305, and I move to admit.
I think you are correct. I don't think we did that. You've heard the motion, 305. This is from EW 2017-0245. It's 2 pages, Commission's response to staff report regarding distributed energy resources. Any objections to the admission of Exhibit 305? Hearing none, so admitted. And we are back on Ms. Lange's testimony. We will go to Commissioner and bench questions. Before I ask for Commissioner questions, I need an exhibit, please. From staff, I would like the attachment to the motion to compel. There are 16 pages, I believe labeled as Attachment A, that are the data requests sent from staff to the company.
Okay.
I'll give a deadline for that, like a week or so in advance. Oh, no, that's just for the future. I'll need that. I'm sorry, thank you, Mr. Gleiser. Okay, with that done, let me also mark down on my list and assign that a number. Ms. Kerr, are you okay with me assigning this to staff's numbering, 219? Otherwise, I can assign myself a number and I'll take care of it myself if it's,
No, that can be, that's
okay.
fine.
219 will be attachment A to the motion to compel that was in this case. We'll deal with the admission as a late filed exhibit. Commissioner questions. We'll start with Chair Roop.
Thank you, Judge. Is it morning still? Yeah, good morning. Following up on, you made a statement that the same consultant in the Ameren case as in this case has been utilized. And the testimony in the Ameren case was that the continuing property records do not accurately reflect what's going on in the market. Can you explain to me why that is important?
I'll do my best. The reference consultant is Mr. John Spanos. So at the time that the list that became the stipulation was written in my direct testimony, staff didn't know about the extent of issues with the continuing property record. Okay, that's first and foremost. How this is done in a rate case, this being distribution system, functionalization, and classification. What Evergy and other utilities do, and staff largely does as well, although we'd have to rely on utility data, is go account by account, and by that I mean distribution account. So using overhead, conductors, and devices as an example. Hopefully somewhere the utility will have a work paper they don't in every case, but in many cases, the utility will have a work paper where they went to the continuing property record for a distribution account, and they represent that the person conducting the class cost of service study had a discussion with in-house distribution personnel about one of two things. And one of the things that those typically are is, by retirement unit in the continuing property record, what is the smallest, most frequently utilized piece of property for that account? Or alternatively, what are a set of frequently installed retirement units of various sizes from which they can perform a regression to determine what the conceptual no-load item would be for that account. And now this varies by utility, using conductors and devices as an example. You know, you may do this just for conductors. So for example, the utility might represent, again, this is seldom if ever in testimony, but often we learn this through data request responses, that the utility will represent that they spoke to a line engineer, and line engineer says, we're using, I'm gonna make up a retirement unit name, aluminum number 50. Aluminum number 50 is what we use for everything. And so then the person performing the class cost of service study for the utility will say, if all of the line miles that we had were built at aluminum number 50, here's what the system would cost based on the feet of other line miles that are in the continuing property record. Now, you get into an issue of the average cost of that, again, hypothetical aluminum number 50. And as Mr. Lutz said yesterday, that's often done at embedded cost. So if the continuing property record is showing the wrong items in the plant accounts, the dollar accounts, from the items that are actually out there in the field, then what your study results tell you aren't particularly helpful, because what you've developed is the historic average cost based on non-historic numbers, or numbers that no longer reflect reality. So I hope that answered your question.
So how does that impact customer and customer rates?
So where you go from there is that would be the step that's used to classify what the company calls the customer allocated portion of the distribution system. Then there'll be another step that occurs where they functionalize, well, and again, different utilities call it classification versus functionalization on this specific issue. But essentially what the company does in a class cost of service study, and the class cost of service studies presented for the last 18 years, is the company says, if we took each of these roughly 12 distribution accounts and said, here's the portion that would exist no matter what demand any given customer has, just by the existence of there being customers, here is a dollar value, and we're going to allocate that to the classes based on the number of customers in the classes. They then, for each of those roughly 12 distribution accounts, would say, based on discussions with our system engineers and other information that we are not including in testimony, and may or may not provide in work papers, and may or may not be based on data that's 1 year old or 30 years old, here is the amount that we think is secondary related and primary related, but not customer related. And so that is what goes into the CCOS for allocation to the customer classes. Now, it affects customer rates on another level, as Mr. Lutz touched on yesterday, in that Evergy, I apologize, I'm talking with my hands, which the court reporter won't catch, but I'm pointing to the important parts here. So Evergy within a rate class has different sets of rates based on the voltage at which customers are served. And those are the rate codes. So if you are a MGS customer served at primary, you will pay different rates than an MGS customer served at secondary. What should be happening at some point, perhaps not in every case, and definitely giving considerations for customer impact and the level of precision and imprecision inherent in CCOS studies, but what needs to be happening from time to time is saying, is that difference between what these two identical customers are being billed for the same service, where the only difference is if they are taking service at secondary or at primary? Is that difference just and reasonable to an extent that you can find somebody on staff willing to sign an affidavit? That's how it impacts, that's the two ways it impacts rates.
The information of which you had requested from the company if you got all the information that you had requested, would that eliminate the need to do a class cost of service study every rate case?
So I think we're talking about item 1. Item 1 is referring to the distribution system. So there's a lot of elements that go into a class cost of service study other than the distribution system. What staff has tried to do is you do a deep dive into the distribution system. When you start having concerns, you keep an eye on it to know when you're having concerns, but that you do not go in depth on this in every case. It's a huge undertaking.
So would having this information in number 1, would that alleviate the time that staff has to devote to coming up with its position for just and reasonable rates during a rate case?
It would take us back to status quo where we could rely on the information. Again, you do this every couple of decades. So in those cases, in the 2010s, the whatever we're calling the aughts, I guess, we didn't do a deep dive in the distribution system because it had been done in the 90s. So it gets us back to status quo, I guess.
So it's not necessarily a time saver or an elimination of work on staff's behalf. I'm hearing you say it's more of a confidence in the data that the end work product would be more accurately reflecting the current situation.
I think that's fair.
Okay. Yesterday, if you were here for Dr. Mark's testimony from OPC, he had advocated doing a distribution study for Evergy and their companies. And I think then he later said, in addition to the continuing property records update, if those two things were completed, what would staff still be lacking that you feel you would still need data to do your job the most effectively?
So, and I apologize because I use this term in my testimony too. The phrase distribution study is probably too vague to be something to put in an order. We probably need to put tighter lines around it than that. But I would see that being done in one of two ways, and this is relevant. I have to say these two ways to answer your question. If we did this by cost categories, and by that I mean if we said, you know, kind of an approach of saying you have this many miles of line that operates at this voltage, what's the cost per mile? If we went that route, I would expect I would issue a DR in each rate case that would say, please let us know, based on discussion with your engineers, if the relative values determined in case XXX have changed. If so, provide update. So that's what I would expect would happen if we went the route of kind of item by item, which frankly at this point would be my preferred route. If we said, and assuming the company said, nope, pretty stable, it still costs a lot more to build primary than secondary, or it still costs a little bit more, there's going to be judgment calls on how much is worth dealing with, but that's the sort of thing we rely on the utilities representation all the time. The second route would be plant by plant with an updated continuing property record. Understanding that decision to pursue the sort of relief that staff pursued with Ameren, to pursue that same relief with Evergy, I am not the person to make that decision. But if that is something the commission ordered, is that Evergy do the sort of thing with its continuing property record that it's ordered Ameren to do with its continuing property record, then we would do the same sort of thing that we did in cases from the aughts and early teens, which is we would look at what they file in their work papers, and if it's not so different that it's shocking, we would just use their numbers. I hope that answered your question. It really is knowing how much money is getting dumped into the distribution systems right now under the PISA legislation, the plan and service accounting legislation, the capital investment plans. It's hard for me to say everything's going to be hunky-dory for the next 20 years, because we don't know what's going to change in the next 20 years. But it would be my hope that if we can get common ground on the values for the sort of thing that are set out in item 1, that we'd be set for another 10 to 15 years or possibly more.
You had also stated in your conversations with company counsel that you were able to get sample customer data from the other electric utilities, Ameren, and I believe you said Liberty said they could supply that. If can you explain what you're getting from those utilities? Can you just expand on that?
So when I refer to sample customer data, what I'm talking about is, as discussed with Mr. Kleiser, it's going to depend on the size of the class or the subclass. But if I say, Ameren, I need 100 residential customers to look at bill impacts, Ameren's response has been, do you want it on a CD or on the SharePoint site? And so what that is what each customer used in each of 8,760 hours at a minimum. I think sometimes they've actually given us 3 years, but I'd have to, not 100% sure on that. But that's what I mean by sample customer data, is what is a customer's usage over the course of a meaningful time period. And then for other classes, that would also include what is 15-minute billing demand data related to that customer. And that has, in the past with Ameren, I believe we've gotten that for large power customers, but not necessarily all customer classes. But again, Ameren hasn't completed their AMI deployment the way that Evergy has.
And you stated that Liberty, from your recollection, stated they could supply you that information if requested.
My recollection of the conversations with Liberty on the sort of items covered in 2 through 8 was they looked at me like I had two heads for thinking, why is it a question? Of course we could provide this. This is what we're doing internally. This is what we need to do, what we're doing. They were concerned why we wanted it in a stipulation. What was the catch?
So based off of your experience of working with the three largest electric utilities in the state. Would you agree with previous testimony, I believe it was Dr. Mark from OPC, as he categorized the reluctance or inability or difficulty of getting information from the company boils down to culture?
I've been involved in conversations to get load research data, hourly class information, rate code information from Evergy since at least 2012. And where those conversations were in 2012, and this is answering your question. Where those conversations were in 2012 is we'll be getting AMI soon. Let's just put a pause on this, because once we have AMI, of course we can do this. When 2014 came around, it was, we're really focusing on aligning, if, I know you recall, other commissioners may not have been part of this or been aware of this. So the consolidation of the rate districts at what is now Evergy, Missouri West was a big deal. And so that put a pause on providing good load research data to staff. When that picked back up, Evergy was in the midst of its transactions with Westar. At that time, Evergy's discussions around load research data, class hourly load data, shifted abruptly. I recall having a conversation with Evergy personnel saying, you know, what did we need? How do we need it? And I looked to Al Bass. Al Bass is the person who does this for Evergy, and said, Al, what are you asking for? You know, because it does come down, do we want it by month? Do we want it by billing cycle? You know, there's all sorts of detail. And I recall saying, Al, tell us what you're asking for. And if it's, I'm gonna bet it's the same thing. And if it's not, I bet we can work with what Al's asking for. And the response from Evergy was, we're tied up with Westar. Al's not getting anything for years. And that has been my experience on the customer and usage information from Evergy from that time forward, is that there's always something else that's a higher priority, and they just can't do it yet. But someday we'll get around to it. And I think that that's what the testimony in this case was. You know, Mr. Lutz said yesterday that, yeah, it would be nice to have this by rate code, but it's not a priority.
I believe I asked Mr. Lutz, has any other state adopted a similar methodology to which staff was proposing to use? I think he stated that it did not exist at any other PSC, to his knowledge. Would you agree with that?
So this is where what it is confusing to me.
Okay, Bill Clinton. What does is mean?
I appreciate the reference. I'm not aware of a jurisdiction, especially in light of PURPA, PURPA 78, that doesn't look for cost causation in any rate differences, the treatment of similarly situated customers. So if that's what we're talking about, I'm not aware of a state that doesn't do that. If what we're talking about is the whole kit and caboodle from the EW 2017 case of where staff said, hey, here's the timeline of, you know, if the commission really wants to prioritize bringing DERs online, here's where we ought to be by the end of the 2030s or whatever that timeline was. I know we refer in that docket to the Indiana model, but I don't recall the details particular to other states, and frankly, I haven't had the time to look at it since 2017.
That's all I had, Judge. Thank you.
Commissioner Hahn is going to have a few questions. I did want to just make sure that everyone is aware, we are going to break at 11:30-ish, trying to accommodate Commissioner Hahn's questions. We will be returning, though, with Ms. Lange for Commissioner and bench questions. Let me ask let's go ahead and we will pause on the questioning for now. We'll return with Commissioner Hahn. She has dibs first. And then commissioners, we have agenda, well, you all have agenda at noon. I was thinking of giving you all an actual hour of lunch until 1:30. We're in the last four witnesses. I think Ms. Lange is probably the major witness here. 1 o'clock? Let's go 1 o'clock. Okay. Where are we at?
Judge, I have your copies of the attachment A, if you want that. I can just bring that up afterwards, or after we adjourn.
Yeah.
Okay.
Change of plans to everyone listening and in the room. You probably heard some of the side conversation. We are making sure our technology coordinator is going to take care of agenda. We're going to go until about 11:40-ish. Commissioner Hahn, go ahead.
Thank you. Apologies for the back and forth there shortly. I'm going to maybe pick up and ask some of the same things I asked yesterday of Mr. Lutz and some of the questions just previously asked by Chair Roop. So yesterday, I did ask Mr. Lutz about the data request or the amount of information that he believed the other electric IOUs do provide to staff. I asked, I'm summarizing from yesterday, do you think that the other electric IOUs have to provide this information? And his response, and again I'm summarizing, was that he didn't, to his knowledge, think that the other utilities had been subjected to these particular 9 questions, and that there had been some difference and distinction in what had been asked by different utilities. Can you respond to that? What your knowledge is of what the other utilities provide at a broader level, and give me some context for his remarks?
Yes, sure. So turning first to Liberty, because it's the easiest one. As far as the items covered in 2 through 5, Liberty, was, I don't recall if we have a literal stipulation provision with them, or if Mr. Dole just communicated that they could retrieve that from the data lake as needed, and it wasn't an issue.
Okay, that's important. They have a data lake, and they can provide 2 through 5, to your knowledge.
That's what they represented to us.
Thank you. Do they provide, sorry, I'm asking another question. Do they provide that regularly, or just in rate cases, or how often?
So we don't need it unless we're doing a specific rate design case, which might occur outside of a general rate case, or a specific MIA case. What we need this for is in a rate case for the 3 relevant periods, but not outside of those instances.
Got it. Okay. I'll let you continue. Sorry. with the
Sorry,
First question.
So on the distribution type data, and we got a little bit better at wording some of these things, I think, to maybe clear up some of the just sort of inherent vagueness or potential for misunderstanding. But there's nothing substantially different between the discussions with the other two utilities from Evergy. And sorry, I'm jumping around in my answer here. That said, as far as distribution type data, we've had early discussions with Liberty coming out of the last rate case about the sort of information we would need to see going into future rate cases. And I would characterize it as a general agreement to disagree. You know, they're not necessarily committing to propose things the way staff may propose them, but that I think we're more or less on the same page as to what data would be provided.
And when you say distribution type data, is that the type of data that would be in your number one?
Yes, stipulation provision 1.
Okay, so they also haven't yet provided it.
We haven't gotten to a rate case. And to be clear,
Okay,
we're not asking, and I don't know how anyone with a background in this material, like Evergy has, would read item 1 to say, we literally want you to reinvent your books and records. That is not the intention.
Okay.
To the extent that's been, so I'm not saying that Liberty has redone its books and records, because that's not what we want, and that's not what we're asking for. With regard to Ameren, we're engaging in very productive discussions regarding item 1, and they've been, again, they're not necessarily, and I wouldn't expect them to commit to what they're going to propose in future rate cases for actual class cost of services, but they're very open to the discussions about what kind of data we need to do what we need to do. Now, as regarding the customer and usage information, Ameren is at a different point in their AMI deployment than Evergy. And I'll be honest, I don't recall what they've literally said they can do today, because they still have 10-15% of customers who aren't AMI. I think where we are with them is conceptually similar to this discussion of saying, you know, how many do you have that are AMI metered? Are they, you know, fairly representative of the remainder that are not AMI metered, and do the math to extrapolate it? I think that's where we are, but I would defer to that order for the details. That being the rate case order in 337.
okay. So in my mind, from your testimony just now, it seems like there's a mix amongst the utilities of what they said they can provide and what they have provided and when it's kind of needed. As in some of the information from the other utilities hasn't been provided yet, but they're potentially working on providing it in a future case.
I believe that is the agreement with Evergy and the order with Ameren.
Okay,
And some of the data has been provided with Ameren. We recently had a really productive discussion with Ameren about non-coincident peak in particular.
okay. Also yesterday, at the very last question I asked of Mr. Lutz was that, did he believe that this data was needed by staff in a rate case? And he responded that this data is, I'm summarizing, needed to support staff's rate design request, but was not needed to support Evergy's rate design. Can you respond to that?
I can, and this is where it's important to remember there are 3 or 4 really different pieces of information at play here. So picking up the distribution data first, we are at a point, given the staleness of data, and given, as Mr. Lutz described yesterday, the departure of the existing rate relationships over time due to stipulations and various orders, we're at a point that we've got to check those relationships. I am no longer comfortable saying equal percentage is fine with regard to the rate design aspects, where within MGS, LPS, SGS, customers are getting charged differently based on nothing more than whether or not they're all electric and based on nothing more than the voltage at which they're served. We're at that point, and it is a point you reach gradually. So that's for item number 1. For the customer and usage information, there's a lot of baggage around the deployment of time of use rates. I'll be blunt, the commission did the opposite of what I told them to do, and then came back and did what I told them to do, but at a time that I said, you just can't do this now, it's gonna make a mess of things. That's the best way I can characterize it. That's where we are. We can't ignore that 15% of customers, for the residential customers, are paying really, really, really different rates. We can't ignore that the intent of those rate designs that I testified in the last case were not cost-based. They were designed to induce changes in customer response to weather. I'm not the staff person who's going to be signing off on an affidavit regarding weather normalization, weather responses, and billing determinants in the next rate case, but you'll have an opportunity to talk to him here in a minute. But if I were, I couldn't say that we can purposely ignore how different the time of use situation makes things on the residential side. Now, this also relates to those disparities for all electric versus general service customers on the commercial and industrial side. They're getting charged really different rates based on their end uses, based on assumptions that were made in the 90s about the costs of energy over time. That was before the SPP integrated marketplace. It was a very, very, very different world. Especially looking at renewables today, that relationship has been turned on its head in the RTO and in the area in which Evergy participates. We have to look at how those customers are being charged differently and say, is it reasonable or not? Personally, I don't think it's reasonable, but here's where we have the problem of we have to see what that customer impact is. We can't just say it's not reasonable, get rid of it, unless the customer impact is minimal or is within a realm of reasonableness. So that's where this third thing comes in of the sample data of we have existing rate disparities related to the time when customers consume energy. And Evergy's position that we saw in that DR response of, well, it's not a problem in the rate case because we're just ignoring it. To me, that cannot be an acceptable answer for the commission.
Okay. I have more questions, but I think we need to pause.
Yep, we're at our 2 minutes before our pre-announced adjournment time of 11:40. Let's go ahead and call it. We will go to recess until 1. We're off the record, excuse me, in at recess.
Sorry, Brian.
let's go on the record. The time having expired for recess, lunch, and agenda. We are returning, stating for the record, this is again Regulatory Law Judge Charles Hatcher. This is file number EO-2024-0002. And we are in the middle of testimony from staff witness Sarah Lange and in the midst of commissioner questions. Commissioner Hahn had the floor. Please continue, Commissioner.
Thank you. Thank you, Ms. Lange. I'm going to start down a different line of questioning that I also asked Mr. Lutz about yesterday. Yesterday, I had asked Mr. Lutz about, level of communication potentially before this hearing. I can't remember exact question I asked, but can you tell me about the level of communication you had with Evergy prior to this hearing today and trying to reach a resolution? And, what was the outcome of that? From the testimony that I read, it seemed like there was not great communication between what the data that was provided and what staff expected the data to be. Can you talk about that communication prior to the hearing today?
Yes, and to be clear, do you mean from the time of direct testimony to the hearing, or do you mean leading up to the filing of direct testimony?
Prior to that as well.
Sure. I think I mentioned this a bit this morning. Based on the conversations that occurred around the time of the stipulation in the rate case, and again, I'm not trying to talk about privileged settlement discussions, but this one it's difficult because there's an overlap of technical issues and settlement issues. But I thought I thought we were getting towards the same page on the sort of information that Evergy would be able to provide, understanding there may be some items where they said, we just can't do it, it's going to cost a ton. And apologize for the ambiguous phrase of a ton, but I thought, based on the conversations that were occurring last fall, or fall of 22, I'm sorry. Based on the conversations in fall of 22 and the fact that these conversations had been coming up in dockets and rate cases for the past decade, I really expected we were going to get, hey, we think it's going to cost a few grand to do a poll study, or hey, we did a poll study and here's the result. I really, really expected that information to be filed around July 1st. And I was literally shocked when Evergy's answers was none of this can be provided, that there is incremental cost to doing every element of this. Mr. Lutz referenced in his testimony that alternative data may be suitable. It would have been great if they would have told us that ahead of time and we could have talked about that alternative data because, again, I thought for item 1, that's what we were looking at. Items 2 through 5, there's been communication on that going back probably close to a decade now. There had been no additional communication from the time of the stipulation until Mr. Lutz's direct filing. Again, I thought it was pretty clear at that point what the information is given the history of the case, so I wasn't surprised that I didn't get questions from Evergy between fall of 22 and July of 23. And so then during the case, there are a lot of data requests, and part of the issue we've run into this, and I'll try not to go on a general, if I were king of the staff type thing here, we do have issues with information kind of getting buried in emails. So to the extent that we have a question of a company and there's an open case on it, we do it as a data request. So, in a different world, could I have emailed some of those questions to Mr. Lutz? Possibly. If I had been hit by a bus, would Mr. Lubert or somebody else know where to look to find those answers? No, so I did them as a data request. So to the extent that Evergy did respond to some of those data requests with useful information, that information exchange did occur. To be blunt, that was very limited, that they provided, kind of full answers to data requests or even you know, hey, we can't give you exactly what we asked, but here's this other thing. And then there was a settlement conference in this case, I think about 2 weeks ago. All I can say is it was not productive. That's within, you know, the confidentiality afforded to settlement. Does that answer your question?
Oh, sorry. Yes, that's helpful. On the stand yesterday, when I asked about communication from Mr. Lutz, he did say that things could have gone differently. He could have done things differently to try to, you know, get staff information, alternative options, if you will, or different information. Do you think that there's anything that staff could have done differently to get this information as well?
Oh, there's always things we could have done differently, but frankly, given the commitment that Evergy made and the way it was worded, I think it was reasonable for staff to assume that if, you know, we have lots of stipulations open at any given point in time, and utilities tend not to be very receptive to us saying, hey, just checking in. You know, where are you on that thing that your deliverable is in 6 months? So, you know, that's where, you know, it's kind of a judgment call of is if that's seen as nitpicking a utility or being proactive. Again, the way that the discussion ended, I don't know what we could have done differently prior to the filing date. Now, since the filing date, I don't know. Maybe we should have done meetings. Maybe we should have done conferences. Certainly what was done was not productive.
Thank you. I also asked Mr. Lutz yesterday about, you know, the ultimate goal of having this data and, you know, what he believes staff's ultimate goal was of having this data. And I know as in his testimony, we've talked about it some at length since then, but I just want to take the opportunity to ask you anyway, you know, if you were given all of this data, what do you think the ultimate goal would be? And, you know, on what timeline?
Sure. So do you want me to go distribution data versus usage data? I hope, because I don't really know
That's
how to
fine.
do it otherwise. On the distribution data, the ultimate goal is making sure that rates that are being charged are not let me get the magic words here.
The microphone, thank you.
Yes. The ultimate goal is that we can recommend to the commission what you need to put into an order to provide rates that are not unjust, unreasonable, unjustly discriminatory, or unduly preferential, or in any way wise in violation of any provision of law. That's our obligation. And so Evergy's rate schedules, as is not uncommon, includes provisions to treat customers differently based on the voltage at which they're served and the overall size of the customer. Rather unusually, Evergy's also includes provisions to treat customers differently based on their end use. Those end use rates have been of concern for decades now. And so to eliminate those end use rates, or at least to make sure that they're cost reflective, this is where the two kind of cross over. We do need the hourly data by rate schedule as it relates to those end use rates, or as it relates to any hourly variation in end use rates. So that's the first part of making sure that our rate structures are reasonable. And whether, you know, would that mean changing them? It could, but frankly, we need them for what is there now. Now, as it relates only to billing determinants, weather normalization, fuel and production modeling, all of those things, Evergy's rates are different today than they were. Evergy's rate structure is different today than it was a year ago. Again, I'm not going to tell the commission you got it wrong. I might want to, but I'm not going to. But at the end of the day, we've got the rate structure at Evergy that we've got. And I don't know how we weather normalize. Luckily, I'm not the witness that has to do that, but somebody on staff has to. and starting that process sooner rather than later for learning how we do that, learning, kind of how to test it. Missouri has been a national leader in weather normalization. But I think it was discussed yesterday about Mr. Proctor more or less developing the technique. I'll give a plug to Sean Lange, who presented at national conferences on weather normalization, weather responsiveness, weather normals. It's not just that we have to be a leader, we have to deal with what we've got, and what we've got are rates that charge customers differently based on the time when they use data. We have to start looking at that information for studying weather responses and for developing NSI, class level peaks, and weather normalized billing determinants and revenues.
Please forget. Thank you. It seems like that could be debated about, starting to weather normalize using time of use rates, and we still have to figure out how to do that. And knowing there's a case coming up, and whatever data is going to take time to compile, potentially, if you have to build systems, years. So how do you reconcile the request here, knowing there's a case and knowing that you likely might not have this data?
Yeah, that's going to be a big problem in the rate case. And I don't know what staff's going to do in the rate case. And we're not going to have a full year of the data. Looking at case timelines, Evergy is not going to have all residential customers on any time-based schedule until the end of the January billing month for 2024. So that data is not going to exist until tomorrow, I guess, at the earliest. So even if we got that, this rate case, we're going to have to do something different, okay? So this isn't necessarily how do we fix the 2024 Evergy West rate case. It's how, whatever mess we're in the 2024 Evergy rate case, how do we make sure that we're not in that same mess in a 2025 rate case or a 2026 rate case? How do we start making it better, and how do we not make it worse?
It seems like going forward, this is going to have to be something that's you're in constant communication with the company to try to obtain data on an iterative process,
I disagree.
Okay, so moving forward, you think that if we compel data one time, then you don't need it you don't need it more than one time moving forward?
Here's where I can't follow what the company's actual position is. Okay, so with regard to customer and usage data, Evergy will file their direct case based on a test year, okay? That's 12 months of data. Evergy has typically used data about 6 months, ending about 6 months prior to their direct filing. What staff does with, I believe, every other electric utility is staff says, and I'm going to do my best here, and I apologize to Ms. Cox if I get this terminology wrong, because it's slightly different for weather response than it is for a billing. Staff will say, okay, give us a more recent 12-month period of class load data, the hourly data, and in this case it would be the rate schedule data, not the class load, so that we can study the response to weather during that time. And now here's where it's likely I'm going to butcher the detail, and I apologize if I make this more confusing than it needs to be. For billing data, we don't do a new update period, but we update the test year through the end of staff's update period. With Evergy, that period tends to be a month and a half to 2 months more stale than what any other utility can provide. So we need a better update period hourly load data from Evergy. So they need, what I'm trying to say is, it appears from Ms. Dragoo's rebuttal testimony that Evergy might be saying, well, we can do this once per rate case at a cost of 40 grand. If that's the answer, if I were the commission, I wouldn't be satisfied with that answer. If I were the commission, I would say, what does a reasonable utility have to do to produce reasonable customer and usage information for use in its rate cases? And I think that that's where, if this is a one-time cost, or if this is, they need $120,000 for every rate case to provide this data, that's deeply concerning about what decisions they're making about how to incorporate this process. Does that answer?
I think I interpreted her testimony differently in the fact that, and a combination of her and Mr. Lutz's testimony differently than that. I interpreted it as we prepare for rate cases ahead, so we have adequate staff to do those things, and we build the systems one time to know how to automate this in the future, and then we prepare with our staff to make sure that it can be a little bit more automated in the future. So it wouldn't, my interpretation again was that it's, that cost one time, and then, continuing costs based upon like maintenance, but not the same startup basically every time.
I hope your interpretation is the right facts. I don't know. I hope what you're saying is accurate, and if so, that's great.
And I'm gonna change my line of questioning briefly. Office of Public Counsel yesterday testified that they would recommend, instead of perhaps these requests, to do two things: a distribution study and a continuing property record audit. Have any other utilities been ordered to do those, either independently or at the same time recently?
Yes. I think Ameren, and I'll defer to the wording in the order, but in the Ameren 2022-0337 case, their most recent rate case, staff raised concerns with Ameren's continuing property record, and I'll defer to the literal wording in the order, but my recollection of what the commission ordered is, this is a problem, talk to staff about how to make it better, at least going forward.
Do you have any recollection of the cost of those items to perform those?
I don't think that has occurred yet.
Okay, hasn't occurred yet. Got it.
And then as far as the distribution study itself goes, as I said this morning, I did throw that term out in my testimony, and I apologize because it's, I think we're in the situation we're in here because wording can mean different things to different people, or it can be chosen to be interpreted in various ways. So what a distribution study means to, or what we would be able to enforce a distribution study to mean with Evergy is probably not very helpful at this point. We probably need more specific language.
Understood. Building off of that, if there is a distribution study ordered, and it does, is recommended by cost categories, as you had previously mentioned, you had also previously said that doing these two items may not satisfy staff's data needs. If you did those items with the cost categories, would that satisfy staff's data needs?
Okay, and I probably screwed this up in how I said this. So, me, personally, am not in a position to recommend that Evergy do a audit of its continuing property record. That, I don't know if that'll be an issue in a future rate case, but that is a different department, that is different witnesses. I have familiarity with it, but I would not be, able to recommend that today, and I'm not recommending that today. For distribution, what we're calling generally a distribution study, let's say that what that looks like is give us, at the highest level, it would be something like, tell us how many miles operate at what voltage. So once we have that information, when we get to a rate case a year from now, there's going to be different miles operating at that voltage. So in my mind, what we would do for the next decade-ish would be, well, what did your miles change? What did your relative cost hold constant? What are the miles? We have to multiply the new math because you've added customers, you've increased system size. That would be what I would hope we can get to through a process to be carried out in this docket.
Thank you. Mr. Kleiser earlier spent significant time walking through Mr. Lutz's BDL-1. And I, like Mr. Kleiser, thought, following the color coding was particularly instructive, though I think that after your testimony, I've never been more thrown off with what the commission could or should take away. I think Mr. Kleiser is trying to, and I commend him for trying to do this through his questioning, find some middle ground, if you will, about what may be achievable for the company, not burdensome, either to the company or to consumers as far as cost. Going to BDL-1, what do you think would be your recommendation after your testimony of what could be reasonably achieved and provided given the company's response to your requests?
So this probably isn't going to be helpful. I mean, one, at anything over 100,000, and I'm picking that as an arbitrary number, I personally would not recommend proceeding in one with anything over a cost of $100,000, and the likely cost would be much lower than that I personally would recommend proceeding with. The problem on 2 through 5 is what we were just discussing. It's really unclear what this means for deliverability when. Is it worth pursuing to some level no matter the cost? I think so. Well, wait, I said that badly. If the cost is in this somewhere between 21,000 and, 100,000-ish range, even if it's not getting us where we need to be to properly do rate cases, yeah, it's probably worth it. But what we really need to be looking at is what do we need to do to be able to do rate cases that we're not dealing with a year's worth of regulatory lag or 2 years worth of regulatory lag in the study of customer responsiveness to weather.
That's helpful. Thank you very much. One last question, and it has to do with attachment A. Well, actually, 2 last questions, sorry. In the last rate case, in your direct testimony, in the data retention portions, it basically sets out the data that Evergy would be providing. And then in attachment A, it kind of morphed into that 1 or 2 pages of, requests turned into 16 pages. Help me understand that.
Sure. Could I have a copy?
Oh, sure. Attachment A,
Yeah. I think it's been pre-marked as 219.
yeah.
Okay, I could go through these numerically, but I think that would not be good.
Please don't.
Yes. If I don't answer your question, though, I'm not
Yeah.
trying to avoid it, if
Got
that's what
it.
you were seeking. So, Mr. Lutz's testimony, Evergy's direct filing in this case, did not appear, or I'll say, it does not clearly state what Evergy has to do to get information and what it will cost. There is nothing in Evergy's direct testimony in this case that wasn't known by everybody in the fall of 2022. So these questions, for each item in stipulation provision 1, as I described earlier, I had to ask, what is this by item? The lump sum of 110 million is not helpful. You know, can we prioritize meters? Is that something that's high dollars in terms of plant balances, low dollars in terms of study? So there are, I think, 10 or 11 questions to each utility asking that. And it's important to bear in mind that Evergy West's distribution system is a lot different than Metro's distribution system in terms, especially of records that are available. I mean, Evergy West has been through a lot of corporate transactions, and Evergy Metro is a multi-jurisdictional utility. So both of these are more complex than, you know, some other utilities might be. So that's a lot of the questions, is why, you know, what is this item by item? Okay? Then the next few was, what is this account by account for each of the 10 to 12 distribution accounts, and whether you lump substations together or not. You know, again, because you could do it item by item, you could do it account by account. Either one would be reasonable. And then to address the lack of work papers, or really the only testimony in the case that addresses what's it going to cost is BDL 1. I mean, to me, that's shocking. You know? So then I had to ask, let me find one here to give as an example. Oh, so another thing that we went through for each item was, you say you can't do it by voltage and by rate code. So then for each item I asked, can you do it just by voltage ignoring rate code? For each item I asked, can you do it by rate code ignoring voltage? So then I asked a series of questions in Evergy, utility name, opinion, what data is necessary to identify item, in this case, secondary distribution costs, by rate code? In Evergy Metro's opinion, what data is necessary to identify it by, to identify the expenses by rate code? And an important thing to bear in mind there is a lot of the distribution expenditures that are going out are done, at least ostensibly, in the name of automation. So if you're adding a lot of plant to reduce expense, that requires a fresh look at how we allocate expense. Because if you're paying for the avoided expense, you shouldn't be paying proportionately for the expense. So that's the bulk of these data requests. And then for each one, okay, what would it cost you to do a sample? You know, if we did something else, what would you do and what would it cost? Those are the sort of information. It's just that necessarily there's a lot of them because we're covering a lot of ground. So I actually set up a matrix to, you know, here's the information I need. Again, unhelpfully for the court reporter, I'm gesturing. You know, here's the information I need. Here's the account I need it from. And here's the subject matter I need it on. And so if you have 12 accounts and you need 5 or 6 things about each account, you get to a lot of data requests in a hurry.
Thank you for the clarification. When I listened to Ms. Drago and read her testimony, it was clearer to me maybe why the estimates were larger, because they have to build systems, you know, or build a system to bring this together. And so if we ask them individually, they may not have an estimate.
May I respond to that?
Yes. I was going to ask for your response, so.
I'm sorry.
Good.
This is
Yeah.
this is what's so troubling about this case. When I keep saying this isn't what anyone contemplated in the fall of 2022, that is exactly what I mean. We never, ever, ever expected Evergy to sit down and redo all of their USOA records. Of course that wasn't on the table. So to come back and say, it'll cost us $100 million to redo everything we do, it's a waste of the commission's time, is what it is. No one expected that. No one was asking for that. You know, in stipulations, there's always the difficulty of how detailed do you get, how general do you stay. Clearly, the stipulation needed to have been worded different, giving Evergy the benefit of the doubt. But that was never what was contemplated, is going back and doing whatever it is that Mr. Gu implies we wanted them to do, because it's not what we wanted.
That's helpful. How many, this is my last question, I think. In total, about how many data requests or even beyond, has staff asked for of Metro and West in this case?
I can give you the numbers.
I believe there's been 213 DRs in the case.
Now, some of those were propounded by Evergy to staff.
Right, I just printed off the total list of DRs.
Thank you.
So there's a total of, I think, somewhere less than 213.
There were
Let's see.
there were less than 132 unique data requests from staff to Evergy.
Somewhere around 187, somewhere
No,
200. Well,
there were less than 132. There were at or less than 132 unique data requests where the content of the question was different in some respect other than just changing the name of the utility.
correct.
Thank you. I think that's all my questions, Ms. Lange. Thank you.
Are there any other commissioner questions? And just fair warning to council, I will be asking the commissioners again before we get to recross and redirect. The bench has a couple questions. I'm not sure how to start this first question. It's mainly an observation. But Witness Lange, you and your counsel just came up with a whole bunch of numbers, and it took you about 30 seconds. And I recall Mr. Fisher asking almost the exact same question. How many data requests were issued? Is that not the same question?
If Mr. Fisher asked that question, that's the numbers that I would have had.
I'll have to check the record, but I have the distinct impression that you were very confused about an exact number. You identified big as relative and were unable to answer direct questions or give a good estimate about the number of data requests back and forth. Is that a good summation of what happened earlier?
No, frankly. I remember being confused as to when he was saying data requests, if he meant the items in the stipulation. Are you referring to when he was talking about the excerpt from my testimony? There was a lot of cross-examination, so I want to be sure that I'm recalling correctly. The issue with my testimony is that he was referring to all data requests, and that's not what my testimony was referring to. I don't have an exact subset for the count of how many data requests I was referring to in that sentence from my testimony on, was it page 17 or whatever that page number was?
And so your answer just a minute ago, how many data requests were there? Your answer to Commissioner Hahn, can you restate that?
There were roughly 132 unique data requests. And it is difficult to answer in that whether you're saying the literal data requests where the only difference was Evergy Metro versus Evergy West.
Okay.
Judge, just to interject, just my recollection, I do remember the witness saying, answering the question that there was 132 specifically. The counsel is saying there was closer to 200, then they went back and forth on whether or not that, and there was, but I do remember the witness specifically stating 132.
You're right, thank you, I appreciate that. Let's change topics. You had mentioned the 1990 agreement, or 1990s agreement. An agreement is the term that I want to focus on, because up until your testimony, I was under the impression that there had been a distribution study in the 90s, and that was what we were trying to redo after a couple decades. But now I have the impression that there was an agreement between staff and the company, possibly other parties. Is that correct?
Well, I think the agreement was how to go forward after the study had been done. So it was how to reflect the relationships between cost of service that were identified in the study in customer rate structures and rate designs.
So there was, though, a distribution study done.
That is my understanding. I was in fourth grade when that occurred, but based on the context that's been presented to me by former staff witnesses and the language in the document itself, I don't think those numbers were made up. And I know that there's just was a lot of conversation in the early 2000s about all the work that had been done on distribution at each of the utilities in the early 90s.
This is a discussion question. I'm looking for your full answer, not a yes or no. Would you compare what I've heard in testimony that staff needs, big air quotes, needs, this data to perform its function, versus staff could do a better job with more accurate data, but not quite hitting that need? I want to hear from you, where's that need? What's going to be the shortfall if there is no additional information?
This is always going to be a subjective view of where rates have crossed over to unduly discriminatory. So that is the caveat. And it's going to come down to what each witness is comfortable with signing their name to when it's time for them to participate in a rate case. At the time that I wrote the direct testimony, so going back to June or before June, whenever the direct testimony was filed in the rate case, whenever this list was drafted, with regard to the customer and usage information, it was, boy, we really need this. Where we are going to be in an Evergy rate case that occurs a year from today, recognizing we cannot incorporate this reasonably into one that's getting filed a couple weeks from now. We need it. We need the customer and usage data. For the distribution data, there's always something we can do to make an imputation or to come up with here's the best we can do in the absence of information. Frankly, we did that in Ameren, and the commission said, no, it's not good enough. So that's up to the commission if we need better data to perform a CCOS. But at the end of the day, I guess to hit this as smack dab on the head as I can. You can always do equal percentage or some other implementation of rate increase to sidestep CCOS and rate design, even if it's a really bad idea. You can't not calculate revenues and billing determinants. You can't. So an option would be a negative, Evergy can't provide the information, let's give them an adverse evidentiary result of that, and let's say, okay, we're gonna impute revenues because we're not sure what the right revenues are. I don't like that solution. Can we say Evergy can't provide what a reasonable utility with this rate structure would provide to calculate revenues and billing determinants and NSI and responses to weather and MIA throughput disincentives and all the other things that rely on that information? I guess we can. It'll depend on how much information and how much time we have as to whether the commission is going to be able to find that to be a just and reasonable result that is not unlawful in some other manner and frankly that complies with PURPA.
Okay, switching topics again, back to Mr. Lutz's direct schedule BDL1, and I'm looking at 8B. We're talking about coincidence peak determinants.
Yep.
My understanding is staff is asking for 15-minute increments versus hourly. Is that correct?
That is what we asked for. If Evergy's problem is that they just can't do 15, they need to do 30 instead, or failing that, they need to do hourly instead, I asked a data request to Mr. Lutz saying, can you give me a couple I say a couple because in regulatory terms it's a couple, I probably asked for 100. Can you give me customer sample data so that I can look and see if that 15-minute relationship to peak is consistent with their hour relationship to peak? What sorts of customer impacts are we going to have, and is this giving us the information we need? And I believe his response to that data request was only if the commission orders us to give it to you.
My question is, can you explain the significance between a 15-minute interval and the hour?
Sure. Can I use you as a residential example?
Sure.
Do you have an air fryer?
No.
Can you pretend you have an air
I
fryer?
do.
If you run your air fryer, let's say that it is going to draw 5 kW, okay? If you have that air fryer on for 15 minutes, and that's the only appliance you have on for 15 minutes, your 1 hour peak is going to be 1/4 of 5 kW. If you run that air fryer for 15 minutes and we're looking at a 15-minute peak, your peak is going to be 5 kW. So demands are done at different levels for different rate classes, for different utilities, for different purposes all over the country. Right now, Evergy West rates use 15-minute peak, and I think most other utilities use 15-minute peak. Evergy Metro uses 30-minute peak, and that's not inherently wrong or bad. But if we're going to start changing up things for those customers, we want to know what it's going to do for those customers. And we want to know if it's really capturing what we need to understand. So if those customers' 15-minute peaks are hitting all over during the day, versus if those customers' 1 hour peaks are all hitting at the hour when SPP says, here's the amount of capacity you need for reliability purposes, and NERC and CERC and all those other acronyms get involved, NERC, SERC, sorry for throwing those in. We're gonna be measuring different things. So it would be nice to look at both of those things to determine which one we want to measure and which one we want to bill customers according to. If we have the hourly loads, we don't need them to tell us the hourly peaks because we can find that ourselves.
Okay, let's switch again. I want to talk about 5 years versus 10 years
Sure.
on the plant data needed. Why isn't 5 years sufficient?
So this, let me just preface by saying it's really unfortunate that this wasn't a conversation instead of a war of motions. 5 years isn't a great idea right now because of when those 5 years fall. Because those 5 years don't get us back to prior to Evergy beginning to spend millions and I think maybe even billions of dollars on distribution. So part of why I wanted 5 years is to see what accounts are really changing as a result of the PISA process and what accounts are fairly stable for prioritization. Another issue that's very closely related to that is what is the effect of automation? Are we seeing expense levels dropping in, let's say, overhead conductors and devices if we are increasing plant levels in overhead conductors and devices? And probably that was a bad example. Poles is probably the best example. In theory, if we're putting up a bunch of new poles, we're probably replacing fewer poles due to weather or other items that could cause pole expense to be incurred. So those are relationships that are studied over the decades, not over, a year or two. Now, that said, this is information that they have to keep on their books every year. This is information they have to compile to file their FERC Form 1 and to file their Missouri Annual Report. This is as basic of a request as you can ask a utility as I can imagine. This isn't a go find archives and pull up data that you don't use every day. This is a, hey, what did you file with FERC? And in fairness, it is at a one up level of detail from what they file at FERC. What they file at FERC is total distribution expense, but that's summed from their actual accounts, and total distribution investment summed from their actual accounts. So does that answer your question?
Yes. On the meetings, there's been a lot of talk about meetings between Evergy and staff. I just want to confirm, I've heard the number 4. There's been 4 meetings since the filing of this case, or perhaps since the stipulation in September 2023. But I have 4 in my notes. Can you confirm that?
The meetings I'm aware of, there was, I did look it up over lunch. So on August 9th, Evergy conducted what they termed a rate modernization workshop, which was not directly, August 9th of 2023, that 1 was not directly related to this docket, 2 included very little, if any, information about anything other than Evergy's desires to do buffet-style rate pricing and prepay. And 3, I have to go only on what is in the presentation for that, because as I confirmed over lunch, that Evergy scheduled that when I had indicated I was unavailable and I was taking my, at the time, foster son to a vacation. So that was 1 meeting. Staff, so the last slide of that August 9th presentation had, I think, the question, stakeholder feedback, question mark, residential rates, question mark, C&I rates, question mark. In response to that, I prepared, or I should say I converted to presentation form, what's been a,
Ms. Lange, can you confirm the number of meetings, please? Just the number.
oh, I'm sorry, 2 at best, realistically 0, excluding the settlement conference.
Thank you. I just got these 4. I believe this is really close to the end. I want to talk about a fuel adjustment clause.
Sure.
The fuel adjustment rate is multiplied by a voltage adjustment factor, which equals the rate charged to customers through the FAC. Is that correct?
I believe so.
Would you define what is a voltage adjustment factor and how does it relate to the information in this case?
Sure. If I can refer you back to staff's cross-examination of Mr. Lutz yesterday regarding what we termed line losses, okay? So the voltage adjustment factor is a reduction of a value for line losses to say that if you are a customer, if you and I are both Evergy customers, you are served at primary, I am served at secondary. Evergy has to put about 2% more energy on the system for every 100 kWh that I use versus every 100 kWh that you use. The line loss factor is the adjustment that is applied to account for that difference. The voltage adjustment factor is that factor as applied to account for that difference.
And would you tie in information that you're asking for in this case to how you're going to calculate that FAC?
Oh, okay. I mean no disrespect, those are two completely different issues. So the voltage adjustment factor is what gets applied within the FAC to account for line losses. The issue where I said in my testimony, we need this for calculating the base factor of the FAC is because staff does what's called a fuel and production model, and the company does what's called a fuel and production model to come up with the net base energy cost, which is the cost of putting fuel into a power plant, net of the revenues received for burning that fuel through its participation in integrated markets, and a couple dozen pages of tariffs that caveat around that Ms. Mantle is going to know, probably staring at the back of my head in anger at how I'm simplifying that. So that shape that staff puts into its fuel and production cost modeling is derived from the sum of hourly system loads. Depending on the utility and depending on the timing and all sorts of other factors, that shape, if you will, of the relationship between the energy consumed in each of those 8,760 hours is adjusted by the response of customers to weather. So when we weather normalize the customer and usage data, that will, in theory, flow through how we model the utility's requirement of energy during the studied period that eventually becomes a very significant input into the FAC base factor.
Thank you. As promised, I'm going to ask the commissioners one more time because this has been really the point of a lot of this discussion. Are there any commissioner questions for Ms. Lange? Excellent. We'll go back to recross and redirect, find my cheat sheet, and we will go to Mr. Kleiser.
Thank you. I'm going to endeavor to make this relatively quick. Just first, for the sake of the record, you use the term FERC, which I think is FERC for Federal Energy Regulatory Commission. Is that correct?
It is.
And you also use the term NSI. That would be Net System Inputs. Is that correct?
Yes, I think in some utilities it's called net system interchange or variations on that, but it's effectively the amount of power that a utility requires to serve either its retail load with wholesale load, depends on the utility. And frankly, I don't recall for Evergy which it is.
You were asked a question by Commissioner Hahn regarding the data, whether or not the data is needed to support staff's case. And in answering that question, you sort of broke it down into 3 buckets. I don't know if you recall that conversation. This was before
do.
lunch. And I think you broke it down into the distribution. I have customer and usage information and sample data. Is that roughly co-aligned with the 3 buckets that you were talking about?
It does. That discussion didn't get to all of the items on the list, but most of them.
Well, actually, that was going to be my thing. For the sake of the record, if you could look at BDL1 and help me figure out which items are in which buckets. I
Sure.
believe the distribution information is item 1 and 8C1, which references back to it.
Yes.
Okay, and then I actually don't know for certain, so I'm just going to ask, what would be the customer and usage information, which item numbers would that be?
That would generally be, and this is in my testimony, that would be 2, 3, well, 2 and 2A, 3 and 3A, 4 and 4A. And then that apparently subsumes 5.
And the sample data information, which ones would those encompass?
So depending on if you're looking at it as sample data for staff to do analysis with, or sample data for customers to see their own bill impact, that would be 7, 8A, 8C3, 8C4, and then a subset of 8D.
Thank you. You had a conversation with Chairman Roop at the very beginning, and one of that conversation involved whether or not the data being requested would result in a time saving for the staff. Do you recall that?
I do.
And you had basically said this would bring us back to the status quo. I think I'm paraphrasing your answer relatively correctly.
Yes.
And there was another further conversation with the bench regarding the need for the data. I assume you recall that. That was more recent.
Yes.
I want to drill down on that for just a tiny moment. In the last rate case, last Evergy rate case, you were responsible for developing rate design, the class cost of service.
I
Correct.
was.
Is my understanding that effectively staff determined that it could not perform a class cost of service in the last Evergy rate case based on the information available? Is that accurate?
I believe the way I phrased it, and I would defer to as it is worded in that docket, that I think I said something along the lines of you can use it as a reasonable check, but don't rely on it the way you typically would. And again, I defer to the testimony. I don't recall the exact language, but that's conceptually.
So when you say bring it back to the status quo, you are effectively meaning bring it back to the point where we can rely on staff's class cost of service for what it purports to be.
Yes.
Okay. And then one last thing really quick, there has been discussion regarding the continuing property record audit as an option, whether or not that's important here or elsewhere. You would agree with me that a continuing property record audit would have other benefits beyond just the class cost of service design, for example, determining whether or not there was plant that needed to be removed from a company's books or checking depreciation rates.
Well, those two things in my mind would be what a continuing property record audit is. The latent benefit of that is that we could use it better for class cost of service.
All right, I have no further questions. Thank you.
And the company?
Thank you, Judge. I had a couple clarifying questions for you. Judge Hatcher asked you about the 1990, whether it was an agreement. Do you recall that conversation?
I do recall that conversation.
Have you ever seen a distribution study that was dated 1994 that we could go look at to see what it was?
Again, this is the ambiguity around the word study. So you could define a study as the relationship of the rates that were attached to that agreement. That's frankly why I would just defer to what the agreement says and use it as an exhibit.
Well, that's what I'm trying to clarify. There's not a document like you would say a depreciation study, right? It's just it's a review that staff did or the utilities did back in the 90s of their distribution plan. Is that what we're talking about?
If you're referring to the document that you objected to staff offering into evidence, is that the document you're referring to? It speaks for itself as to what its contents are.
That was a stipulation and agreement that I signed 27 years ago that didn't have a study in it. It just had some agreements on how to proceed forward, right?
I disagree.
Do you? Okay. Well, is there a document that I can look at that says distribution study for Kansas City Power and Light Company, dated whatever date it would be?
I don't know the literal title of documents that I don't have in front of me, no.
Well, can you tell me, have you ever seen something that you would declare to be a distribution study?
I would consider that document that's setting out the relative prices for rate elements and the contents of rate elements. That to me falls under the umbrella of distribution study. And as I said, maybe distribution study isn't the most helpful term.
Are we really talking about your desire to have staff do a deep dive into distribution system analysis?
I'm going to object to this line of questioning. We're talking about a study that hasn't been entered into evidence.
Judge, I'm trying to understand. She says we need this data to do a distribution study. What does that mean? Does that mean like a depreciation study that's required to be done, or is it just a desire to look more into this particular topic?
Ms. Kerr, I did not hear what your objection was.
I'll withdraw it. Never mind.
Okay, go ahead.
I think his second question was clearer, and I can answer it. I think. My need as a member of staff to provide a recommendation to the commission concerning the justness and reasonableness of rates is information to support rate elements that cause price discrimination, and I don't mean that in a pejorative way, it's just what you call it, among otherwise similarly situated customers. You can get there a lot of ways.
Well, I guess, like, the commission rules say you need to do a depreciation study every, 3 years or 5 years? And you're required to do that. There's not anything like that, is there, that's comparable on a distribution system study?
There's a statutory requirement of setting just and reasonable rates that are not unduly discriminatory.
And that's really an ultimate decision that these 5 commissioners have to make in each case, correct?
Absolutely.
Okay,
Never mind.
a legal conclusion, so that, the staff recommends what we should do in a rate case. Ultimately, the commission decides what are just and reasonable rates. You decide if you think there maybe is there differences between costs that maybe ought to be reconciled. Maybe the residential rates are not earning the same rate of return as the industrial rates. You point all that out in a cost of service study. Ultimately, you give it to the commission to decide what are just and reasonable rates. You would, if I understand your testimony, you would like to be able to do a deeper dive into what distribution relationships are out there, right?
What is throwing me in the question you're asking is that you're not putting bounds on it. There are lots of things about the distribution study that aren't relevant that I have no interest to waste the state's time in looking at. I specifically need to look at those characteristics that are reflected in Evergy's existing rate design and rate structure. That's all I'll look at.
Okay, well, if the commission would say out of this docket, Evergy, or staff, go do a distribution study, what would you do?
Again, the theory I have right, or the best idea I have right now would be to say, to use the numbers I've been using all morning, what can you look at for line transformers for 10 grand or less? What can you look at for meters for 10 grand or less? Can you get us better information than we have today about the costs of running a mile of overhead conductor and poles that operate at 345 kV? Those are the literal questions I would ask.
Those are the literal questions with a lot of subparts that you ask in this docket already, right?
Objection. Was that a question?
Is that right?
There's an objection. Mr. Fisher, do you have a response? First of all, Ms. Kerr, what's your objection?
I was waiting for a question there, but he added a question mark, so never mind.
Okay, go ahead.
There are data requests addressing some but not all of those items. There definitely are not data requests that have been propounded that address what can you do on each of these topics for 10 grand. And I don't believe, as it regards those questions that I just described, the company has provided answers to those data requests that involve a quantification or anything other than a statement that it isn't how they currently keep records and they can't provide it and they can't be compelled to provide it.
Okay, let's change topics a little bit. There was a question from, I think, Commissioner Hahn about, you know, what we could have done looking back, how things, our communication could have been better, and that conversation, do you recall that?
I do.
Would it surprise you to know that the company did not realize until your position statement was filed that it was your position that it would be imprudent for Evergy to expend the lump sum estimate provided in attachment BL1-1?
You're asking me to speculate on how the company read my testimony and
I'm
rebuttal?
asking you if you'd be surprised about that.
I would, yes.
Okay. Would it be surprising to you too that there was nothing that we understood from your testimony that you were abandoning your request for data section, set of data number 1 in this case?
Objection, speculation.
Can you restate the question?
Sure. I was asking whether, I guess it would surprise her that there was nothing that we could perceive from your rebuttal testimony that you had abandoned your position, you didn't want the set of data number 1.
To be very clear, staff has not abandoned pursuit of the information in Data 1.
Okay, so you're,
Mr. Lutz offered alternative data. He declined in either his testimony or in response to staff DRs to indicate in any manner what that alternative data may be, and I specifically recommended keeping this docket open to pursue alternative data.
but the alternative data would be different than what you've asked for in data request number 1.
I disagree. I think the company used a very unusual interpretation to give them the benefit of the doubt as to what staff requested in what it committed to provide for item number 1.
I think that's all I have. Thank you.
Thank you, Mr. Fisher. That will take us back to redirect.
Thank you. Let me get my questions together. Now, yesterday, Mr. Lutz had testified that perhaps staff is asking for this information for its own rate-making purposes. Is that an accurate presumption for Mr. Lutz to make?
Evergy's existing rate schedules treat customers differently based on the voltage at which they receive service and the end use at which they receive service. Staff is aware that Evergy does not have that information by rate schedule. So to the extent that staff is pursuing what I'll refer to as continuous rate design, I guess that's its own purpose in that it's not part of the existing rates. But the purpose of doing that is to minimize the amount of assumptions and other guesses we have to make about how customers with the same equipment and the same size use energy on different rate schedules, and just look to how maybe it would make sense to align those cost elements across rate schedules or across classes to avoid the need to get as detailed in the data.
But you're not doing it for your own rate-making purposes, as he has testified. I mean, is that
Making things simpler and easier, I guess that's my purpose. I mean, I'm not trying to. Yeah, that's all I can say.
Now, Mr. Fisher asked about rate codes, voltage levels. Why would staff ask for this?
those are existing discriminatory pricing features in Evergy's existing rate schedules, and staff from time to time has to review the reasonableness to ensure that they're not unjustly or unduly discriminatory.
And Mr. Fisher asked about staff's request for line and transformer costs by rate code. Why would staff make that request?
So line and transformer request by rate code is potentially one of those items that we could move away from, to the extent that we price that by voltage and customer size rather than by rate code. That said, existing facilities charges at Evergy are designed to assume that customers served at primary do not cause line and transformer expense, despite Mr. Lutz's response to a DR, in this case, that some line transformers are used by some primary customers. I'm looking at Mr. Lutz to make sure that I didn't misremember that data request, because that is there has been some productive discovery in this case. That is an element that was good to know. We frankly hadn't thought to ask that question before.
And Mr. Fisher also asked about changing Evergy's computer system. Did staff believe Evergy had access to the data that staff requested in the last rate case when it asked for this information?
We understood when we entered the stipulation and agreement that Evergy couldn't pull the answers to those questions off the shelf. What we understood the stipulation and agreement was going to get us, for lack of a better word, was progress on what I'll call the low-hanging fruit of that information, and cost estimates and process plans on everything else.
So now Evergy signed this stipulation voluntarily, right? As far as you know. I mean, they weren't forced to sign the stipulation and agreement, the August 22 stipulation and agreement.
Staff and Evergy, and I believe maybe MECG and maybe OPC, I'll defer to the agreement itself, entered into the stipulation.
And Evergy committed to provide the data that's listed in, I believe it's kind of outlined in staff's exhibit 204 and BDL 1.
Well, they committed to provide what they could
Right.
at a I guess what I'll call a de minimis cost, or to provide what they would have to do to provide what they didn't provide, and what they thought it would cost to provide what they didn't provide.
Right, and if they couldn't provide it, then they'd give us a cost estimate as to what it would take to get that information, basically.
Let me look at the language here.
I mean, the language of the stipulation is, if the requested data is not available, they'll identify and provide the data, and if the requested data is not available or cost prohibitive, they'll open this EO docket and they'll provide a reason why it can't.
Yeah, that I think
Basically.
is the language something like explain why they couldn't provide it.
Right,
And that's a critical part that is not in the direct testimony, that doesn't move us past where Lutz was in his rebuttal testimony in the rate case, and I apologize for Mr. Lutz, in Mr. Lutz's rebuttal, he said, we don't have it that way. So to me, what was gonna be a really valuable output of this case for the things where the production costs weren't de minimis would be, here's what we would need to do to get where the utility thinks would be the reasonable way of providing that data.
So Evergy's agreeing that it would provide its individual estimate of the cost if it could produce the data. Slow down. So Evergy agreed that it would provide the individual cost of providing that data if they didn't have it. I mean, that's the language of the stipulation. Right?
And explain what they would need to do it.
Okay.
Yes.
So it would be fair to say that staff expected Evergy to either already have the data or have a plan to determine how much it would cost to obtain that data.
Yes.
Okay. So you wouldn't expect, okay, sorry. Now, one of the questions that came up was the number of data requests, just DRs, discovery data requests, what I'm talking about. Now, you sent DRs to Evergy, directed at Evergy Metro and Evergy West.
In some instances, the data request, where it wasn't really pertinent to what their literal books and records would be, where I would know there would be different answers, or to what processes would need to be undertaken where I would strongly suspect there could be different answers. I think I tried to write the data requests to include a sentence that said, we're directing this to Evergy, but if we're directing this to Evergy Metro, but if West answer is different, please explain.
Okay, but a lot of the DRs that you sent, that would account for the duplicate, so to speak, DRs, that basically the same DR went to Evergy West that went to Evergy Metro.
Yes, where it would relate to things like their books and records that we know are going to have different answers if they had answered them.
Okay, so that would account for, say there was over 200, say if there were 200 DRs, maybe half of them would have been to Evergy West, half to Evergy Metro. And that may have been where the confusion came in as to the number of DRs that we were talking about.
I think there were approximately 132 unique DRs, recognizing I may have made a mistake in counting Excel rows, but I think it's about 132 unique data requests.
Okay. And so this 132, like one might have been Evergy Metro, one was Evergy West, but it was the same question to both.
No, so the 132 is accounting for where I know I asked the same question to both.
Okay, right.
There may have been another one or two where it was duplicative and I didn't catch it.
Okay. Now, does the stipulation include asking for, I guess you've already, the stipulation, you've said, included asking for individual estimates for the different types of items, for the different items of data, right?
Yes.
And so, would those asking for individual estimates allow the commission staff and the company to prioritize studies and prioritize what kind of information that is more important, or?
That was the intention, yes.
In data item 8B and 9, you talk about NCP demand charges. Can you explain the difference between NCP and CP, that's non-coincident peak, and coincident peak, and why that difference is important?
Yeah, so a non-coincident peak, running through the example with the judge earlier, would be regardless of the time of day that he turned on his air fryer, and whether we're looking at 15-minute or 30-minute or hour or 5-minute, whatever time during the course of the day, and typically in the billing context, like we're talking about here, we're saying within a month. And that would be a billing month, which is not necessarily a calendar month. The NCP is the time or the amount of energy used in the interval, which was the relevant interval in which the highest amount of energy was used. Now, we are calling the alternative to that, in the rate-making sense, the coincident peak. In reality, we don't know the coincident peak until after it has occurred. So in rate making in general, when we refer to a coincident peak, we're saying we're looking at a total amount of energy used in a month or a year or whatever it is. This was the interval in which the system used the most energy, and we know in that interval who used what because it's already passed. We can't do that for billing purposes. So for billing purposes, and this is, again, it's not really spelled out because this is a common feature among co-ops, munis, and Evergy and other jurisdictions, what we're saying is we're going to define a time period that is presumptively coincident. And so it would be usage during that time period that meets those criteria. So for example, if we said what we're looking at for coincident peak is 4 o'clock to 7:59, then it would be the 15 minutes or the hour or whatever between 4 o'clock and 7:59 for the month in which you used the most energy.
Now, when you're talking about information that's been provided or can be provided, you mentioned an agreement with Evergy and Ameren. Did you mean Liberty?
Yes, it was brought to my attention during lunch that I apparently misspoke and said that we had an agreement with Evergy about providing the information discussed with Evergy, and that should have been Liberty or Empire or Algonquin or whatever whatever name we're going with today.
Okay, thank you. And then you also mentioned NSI in a response to Commissioner Hahn. I want to miss Commissioner Hahn's questions. What is NSI?
I tried to address this with Mr.
did we do
Kleiser. I'm not confident if for Evergy it is net system interchange
Oh, okay.
or net system input, but it's one of those things.
Okay, all right, sorry. And the judge asked about FAC voltage adjustment factors. Do those factors differ from the voltage adjustments included in non-FAC rate differentials?
At a given point in time, yes. At another given point in time, no. Ideally, we align those from rate case to rate case. Again, I look back to Mr. Lutz. I think we've missed that in a couple now, haven't we? They're not off by a lot. They're pretty close, but yeah, we probably do need to tune those up for Evergy.
Now, we had a discussion about that staff was working with some other companies and that there was a couple workshops that you've had with Ameren on some of the similar issues. What kind of information, or what are you asking for from some of the other, from Ameren? What are you getting from them?
It is a workshop, and I expect their presentation from our most recent workshop will be available to the commission, any day now. They said they're gonna file the presentation. But a couple of obvious examples that come to mind is a conversation Tom Hickman presented, where he stated, that Evergy, or I'm sorry, that Ameren, isn't necessarily on board with charging the same metering charge for customers in all rate classes that have those meters, but that they were looking at, the appropriate number of bins in which to look at meter costs. And so when I say bins, there might be at a given utility 200 or more different literal meters. You get a new serial number from your vendor, you probably have a new retirement unit, different things like that. But that there's some fairly obvious groupings of, these are the sorts of things that, this kind of meter would be what would typically be installed for a detached residential customer or a small business, versus this is the kind of meter that you would have for a smelter, and a lot of things in between. So where that discussion is now with Ameren is looking at, I think we talked about 6 bins was his guess at that time of what might be reasonable, but he was gonna dig into it further. So that's an example of where we are on the meter costs. On the equivalent of the customer and usage information, it's my understanding that Nicholas Bowden, Dr. Bowden perhaps, I don't recall for sure, it's my recollection that he stated that what DR, or what the stipulation provisions 2 through 5 do, he did have to buy a new laptop, but he's running that on his laptop to provide hourly summations by rate code, and to look at the sort of coincident peak information and that sort of thing. Ameren's doing in-house, and I would assume that it's not a $1,000 Staples laptop, but Ameren is, at this point, I understand it, able to do a lot of the customer and usage information in-house.
Okay, thank you.
Bins, BIN, like a bin you would put your gloves in.
Ms. Kerr, we do have 3 more witnesses and only about 2.5 hours left, if my math is correct.
I don't have any other questions. Thanks.
Thank
Your
you.
Honor, I'm sorry, one really quick bit of business, if I may. Yesterday, there was a movement. Yesterday, staff moved to admit onto the record an exhibit 213.
Thank you. I'll get that to at the end. You're talking about the exhibits?
No, yesterday, well, I am, but yesterday, staff moved to enter an exhibit, which I believe was 213, which was the 1996 agreement that was objected to, and the objection was sustained on the grounds of relevance, which made sense at the time. However, given the testimony today, I would argue that the relevance for that document has been established, and therefore I would make the unorthodox move to ask that staff's exhibit be readmitted. Again, I believe it was 213, subject to check.
It was. Mr. Fisher, do you have any, or care to make any response?
Well, I did ask some questions about it. I have to admit that. I still think it's not relevant to what we've been talking about. It's apparently not a distribution study. It's an agreement that was identified back in the 90s, and that's all it was.
Mr. Kleiser?
Very briefly, all I'm going to say is we've been talking about it now for quite a bit of time. It seems silly to have a document discussed that's not in the record. For the completeness of the record is all I'm asking.
Could have been filed with the testimony. Ms. Kerr?
I'd have to agree.
Excellent. Overruled? Thank you. Ms. Lange, you are excused, subject to recall. Let's get Mr. Stallman. Thank you. Oh, sure. You can go ahead and have a seat. Yeah. I don't know if we do the whole standing thing. And we have Mr. Stallman on the stand. Thank you, sir. Do you solemnly swear or affirm that the testimony you provide today will be the truth?
I do.
Thank you, and staff, your witness.
Thank you. Good afternoon.
Good afternoon.
Could you please state your name for the record and spell your last name, please?
Michael L. Stallman, Stahlman,
And by whom are you employed and what's your position?
Missouri Public Service Commission as an economist.
And have you prepared and filed testimony in this proceeding, specifically rebuttal testimony that was filed on December 15th, 2023, that's been previously marked 203?
I'm not positive on the actual exhibit number, but yes,
Do you have any changes or corrections to make to any of those documents?
none that I'm aware of.
If I were to ask you the same questions in that document today, would your answers be the same or substantially the same?
Yes,
And are those same answers true and correct to the best of your knowledge and belief?
yes,
I offer exhibit, what did I say, 203 into evidence and tender to the witness for cross-examination.
You've heard the motion. Are there any objections to Exhibit 203? Hearing none, so admitted. The witness has been tendered. Mr. Kleiser.
In light of the hour, I will forego subjecting Mr. Stallman to cross and move right along. No questions. Thank you.
Mr. Fisher?
In light of the hour, I'll just ask a few, if that's all right, Mr. Stallman.
Sure.
I'd like for you to turn to page 3 of your testimony, and particularly where it starts at line 5, what data does staff use for weather normalization of load? You see that?
I am there.
Okay, then you say, as an answer, for the regression analysis portion, staff needs at a minimum the daily energy used by each customer class for a 2 or 3 year period from the company. Is that right?
Yes.
How does staff intend to manage this regression analysis for the residential class, given the recent migration of customers to new rates?
That really depends on what data would be available. That is a big question. I'm not sure what data is going to be available from Evergy to handle that migration. It is of great concern, and to some extent, I mean, the question itself is almost like asking what my bidding strategy is for a poker hand before the cards are even dealt. I really need to see what is available and what we can reasonably achieve.
Well, let's assume the data that's available is similar to data that you've had in the past.
Okay, so from the past, if I believe Evergy has been able to get me the hourly load by a rate class being such as residential as opposed to the rate code. And so there might be the ability to look at some changes, but that assumes an awful lot of information. The big issue that we have in the upcoming case is the differential in time of use rates.
And assuming we have the same kind of data we had in the past, you would be able to do a weather normalization, is that right?
I honestly don't know because of the changing in the different rate codes. What would be ideal is if I could give staff witness Kim Cox like a usage per customer per the time block weather normalization adjustment. And just with the difference in the way that the data would be coming with the rate code switching, that's really going to be hard to figure out how that or the company are going to be able to do a weather normalization. And just for clarification, the importance of the weather normalization is to figure out what the revenues are in a rate case. So when the commission issues an order, it's usually a revenue requirement of an increase of, say, $50 million. The question is $50 million on top of what? So there can be tens of millions of dollars of questioning on what their actual revenue is because of the high differential in these time of use rates.
Let me ask you this question. On page 3 of your rebuttal, I think starting at line 10, you describe your reliance on daily weather data from the Midwestern Regional Climate Center. Do you see that?
Yes.
Is it true that the normal weather obtained from that particular place is an arithmetic mean of temperature over a 30-year time frame?
Not precisely, no. So the information we obtain from the Midwestern Regional Climate Center is the daily high temperatures and the daily low temperatures. There is hourly data available, but that record is a little bit more questionable as far as how that has, if it has all the hours for the full 30 years.
Typically,
But-
it's been a daily.
But
Look-
we do get the daily temperature, high temperature and low temperature from that center. And then then we used a ranked method. So we are not using an arithmetic
Okay.
precisely for each calendar date.
I don't want to go too far in the weeds, but it's really a look at 30 years worth of weather, right? To try to figure out what's normal weather.
To get to what we have used historically as normal weather, that is 30 years.
Okay, on page 7, line 5, you state, weather normalization of customer usage on the remaining time-based rate plans will require.
Can you hold on a
Oh,
second?
I'm sorry, sure.
You said
On page 7
page 7. Okay, line 5.
and line 5, yeah, here, let's go to that. It says weather normalization of customer usage on the remaining time-based rate plans will require hourly customer usage, and then parentheses, and customer counts, parentheses closed, by rate code. You see that?
Yes.
Would you describe how this hourly data would be used in the weather normalization process?
All right, so just to be clear, there's two different topics that we're discussing. One is normal weather, and the other one is weather normalization. Those are two different things. Normal weather is determined on the 30-year, the ranked normals that we obtain from MRCC. When you're applying weather normalization, you're looking at how to apply normal weather into the to come to an adjustment to account for the differences between that normal weather and the actual weather. So the way we've done it historically, the assumption is that we don't really care what happens when energy is used in a particular day. That we've been satisfied with that. We just need to come up with a daily total. But now that hourly rates are important, so it becomes a lot more. It would challenge a daily assumption. That you would not apply a base factor to all hours of the day because just using physics, you're going to use more energy to cool down your house on a hotter day at the peak hours than what you would do on the same day to cool down your house in the morning. The thermodynamic equation on that's quite clear. If we just say that the heat transfer equation is a function of the differences in temperatures between what you're trying to cool your house down to and the outside temperature. So the idea that we can just apply a daily factor and still get a correct result, I think, is really being challenged in here. That's why we need to look at the things on an hourly basis.
And that's because we've got 10 to 20% of the residential customers on a higher differential time of use rate?
Yes.
Okay. In the past, has the staff calculated daily weather estimates in order to arrive at class weather adjustments?
Can you repeat the question? I'm not sure if I quite understand it.
Has staff calculated daily weather estimates in your weather normalization process in order to arrive at class weather adjustments? Do you make class adjustments?
So if I may be misunderstanding your question, I'll answer so we will calculate an adjustment based on the daily actual temperature and the daily normal temperature. And so when we get data, there's a couple different data sets that we use. One data set is based off of what is billed, and the other data set is based off of sample data that the company provides on a daily basis. And so we use the shape of the daily basis to come up with an adjustment factor for each bill cycle. And that then gets totaled up into an adjustment on a revenue month for each large customer class. At least that's how we've historically done it.
Is that based on hourly class AMI data or hourly class load research data?
There has been hourly data provided, but it's been based off of sample data, is my understanding.
Okay. Well, this is an area that gets over my head quickly. But have you ever heard people say that rate making is more art than science?
Honestly, no, but
Okay,
I will accept it.
That's all right. Thanks. That's all the questions I have.
Thank you. Sorry, I got to turn to my cheat sheet to make sure we're going in the right order. It is? Yes. Okay. Commissioner and bench questions. Are there any commissioner questions for Mr. Stallman? Hearing none, we'll go to bench questions. The judge does have a couple. In your rebuttal testimony, you described the process that staff uses to develop its normalized weather-related adjustments based on a regression analysis of 2 to 3 years of daily customer data and daily regional weather data. My question, is that the same process staff has used over the years in electric rate cases?
In electric rate cases, that's my understanding. We've, both utility and staff have had very similar methods in approaching a weather normalization adjustment.
Is it staff's belief that the implementation of AMI and the data it collects of each customer, is it staff's beliefs that that should allow staff to complete its weather-related regression analysis for the development of all customer rates, including TOU rates?
Yes, with TOU rates, getting accurate hourly information will be very important, and this is just to get the proper revenues because of the high differential. So if you're using energy at 6 a.m., you can be charged like 36 cents, where if it's 6 p.m., reverse that, 6 a.m. you'll be charged 6 cents, and 6 p.m. 36 cents. That's a very, very large difference in revenue. And that's what we are worried about, especially in the coming case.
Do Liberty or Empire and Ameren provide this customer data used for weather normalization, the same that staff is asking of Evergy?
So because Liberty and Ameren haven't had the large differential time of use rate customers, we haven't asked for it in a rate case yet. But based off of a working docket with Ameren's counterpart, he would be Dr. Nicholas Bowden, I believe this data would be available. And Ameren has also provided data more readily than what Evergy has historically. We've had difficulty. It even went into a discovery conference in the last rate case.
Mr. Lutz, in his SIR rebuttal, testified that he doesn't know how staff is going to use the weather data requested. His belief is that the process of how to do that is still under discussion. Is that related to your answer, your example about poker, that you need to see the cards before you can make it?
Yes, that's precisely it. There's the theory that we know that energy is going to be proportionally used depending on what the outside daily temperature is. That explains a lot. Plus, in this case too, we have the time of use factor that is trying to encourage people to not use energy typically when it is really hot for the summer months. You're trying to shift usage to outside. And so we really need to start looking at the particular hours in which time energy is used, and for the rate code to make sure that the weather response is the same or not.
Thank you. The bench doesn't have any more. I'll ask the commissioners just one more time. If any commissioners have any questions, they do not. Let's go to recross examination. Mr. Kleiser.
Just very quick, you would agree with me, so you had a quick briefing discussion with the bench regarding AMI meter deployment. Do you recall that?
Yes.
You would agree with me that AMI deployment should make hourly data available by rate codes?
Yes.
And for the sake of the record, AMI is Advanced Metering Infrastructure, correct?
I think so.
No other questions. Thank you.
Thank you. That'll take us to the company.
No questions, Judge.
Thank you, and redirect.
No questions, Judge.
Thank you. Mr. Stallman, you are excused, subject to a very short period of recall. And our next witness will be Ms. Kim Cox. Please come on forward. Thank you. Please raise your right hand. Do you solemnly swear or affirm that you will tell the whole truth during your testimony?
Yes, I do.
Thank you. And your witness?
Thank you. Good afternoon.
Good afternoon.
Could you please state your name for the record? Could you please state your name for the record and spell your last name?
Kim Cox. Last name is spelled C-O-X.
And by whom are you employed and what's your position?
The Missouri Public Service Commission. I'm a research analyst.
And have you prepared and filed testimony in this proceedings, specifically the rebuttal testimony, your rebuttal testimony on December 15th, 2023, which has been marked as Exhibit 200 in this case?
Yes, I did file a rebuttal. I'm not sure on the exhibit number. I'll take your word for it.
And do you have any changes or corrections to make to that document?
I would like to bring up that I do have a different affidavit that has been filed within the case.
Okay. And I have, that affidavit has been filed in EFIS.
Yes, it has. Any objections? So affidavit.
Okay. I don't think I need to move to have it.
I was,
Do I
I
need
was
to
being
have
a
it moved
little
to-
facetious, but no, it was a substitute affidavit. So without any objection and seeing none, I will accept the substitute affidavit. No need to provide me a copy or anything.
Okay. Okay, other than the affidavit, are there any, do you have any changes or corrections to make to that rebuttal testimony that was filed?
No.
So if I were to ask you the same questions that are set forth in that rebuttal testimony that was filed, would your answers be the same or substantially the same?
Yes.
And are those same answers true and correct to the best of your knowledge and belief?
Yes, they are.
I offer Exhibit 200 into evidence and tender the witness for cross.
Thank you. You've heard the motion. Are there any objections to the admission of Exhibit 200? Hearing none, it is so admitted. The witness has been tendered. Mr. Kleiser.
Yes, good evening or afternoon.
Good afternoon.
I would prefer not to, but there was a question that was deflected to you from Ms. Lange, so I'm going to have to ask you. Do you have a copy of Schedule BDL-1 in front of you?
I do, but it is in black and white, so if you would, thank you.
And I believe, if my memory recalls correctly, this was a while ago, the questions concerned data items 8C3 and 8C4. That'd be on the opposite page. Can't remember if these are the right numbers or not. And I believe a question I had posed to Ms. Lange was whether or not the proposal set forth by the company would fully resolve the issue for staff. And I believe that, I don't need to say what she answered, I'll just ask you the same question. Would the proposal set forth by the company for those to completely resolve the issues, in your opinion, for staff?
Resolve the issues for staff, which, I just want to make sure which issues. For these two specific ones?
Yes.
So within my testimony, I do know that Ms. Lange did advise to ask me about these. I would like to state, though, within my testimony, I do talk about 2, 3, and 4, so I'd like to leave it as her answer.
Fine then. In that case, just to keep things moving along, does the answers to 2, 3, and 4 completely resolve this issue for staff?
Do these answers within this?
Yes.
No.
And is the issue there one related to timing?
So, as Ms. Lange stated, 2 and 3 is in regards to the customer counts. We see them, I guess, as one now, based off of the testimony that's been provided. Number 4 is the usage, the hourly usage. So your question was, are they resolved at this time?
If the company were to make the cost estimates necessary to make these deliverable, does that fully resolve the issue in staff's mind, in your mind, or are there other issues outstanding?
With what I do, my analysis, it would be resolved.
All right. No further questions.
Thank you. And Mr. Fisher.
Yes, Judge. Ms. Cox, on page 2, you do talk about,
Can I,
I'm sorry, sure, go. Take your time. I was just going to refer you to the top of page 2.
okay?
There you say you're really addressing or what we call the data set 2, 3, and 4. That's the focus of your testimony, right?
Correct.
Okay, and each of those 3 data areas include a subpart discussing service at different voltages. Is that right?
Yes.
And are you seeking data for rate codes that incorporate a voltage element, like, for example, the small general service secondary or small general service primary? Is that what you're kind of looking for?
Well, actually, we're looking for this for all rate classes. Specifically, residential is one of the top priorities for myself.
Even though it doesn't have a specific voltage element to it?
Correct.
Is it true that the company provides billing determinants and revenues by bill component, which would include customer counts, for the test year, the update period, and the true-up by rate code and by voltage?
So, yes, the answer is yes, they do provide it. However, in the last rate case, the customer counts that they provided were questionable. And had we had that information for the first and the last of the month, we would have known better what those customers were doing month to month. So, I don't know if that answers your question.
I heard testimony, I think, from the previous, or maybe it was from Ms. Lange, that, was it the last rate case where we were maybe 4 weeks or 6 weeks slower than somebody else?
I believe she testified that it was a month,
A month,
I
okay.
believe.
And that's really significant to your work?
Yes, the closer we can get to real time is definitely significant.
Okay. Are you able to determine switchers with customer counts you currently receive from the company?
For which class are we talking about?
I think we're talking about the residential class.
For the residential class, actually in the last the rate case, I did ask for rate switchers and was advised that that was just too much information to provide.
Okay, well, on page 9 of your testimony, you provide information about the customer rate choice and switching activity that's the company's been reporting on in the EW docket on time of use rates.
Yes.
Have you been monitoring the subsequent updates on that?
Trying to, if I have time.
Have you noticed a high number of customers, or that there are a high number of customers on the default peak adjustment rate?
I do see that there is that is the highest number at this point in time.
Would you agree that there are really a small amount of switching that has occurred thus far?
I would agree thus far. We don't know what these customers are going to do in the future. When you put seasonality into it, they may be switching if they know how to work the system.
Okay. Is the sum of interval usage by interval by rate code requested in data request set 4 expected to be used in adjusting the test year revenues, or is it for rate design purposes?
So the information that's requested is not used to, maybe if I can just kind of walk you through it. Test year is test year. Those are actuals. And from there going forward, we do make adjustments at the rate code level. I did in the last case. I made adjustments at the rate code level, but I was not able to do weather normalization, MIA, or 365 at the rate code level. And I was also not able to look at rate switchers because I wasn't given the data to do so.
We did get to the final end of that case, though, with new rates, right?
We did get to the end based off of the stipulation.
In your testimony, you detailed 2 data requests, 69 and 140.
Yes.
And on page 5, about line 15, you indicate that both are not sufficient responses. Is that right? The responses directed to staff to the company's direct testimony that did not provide any additional details, and that you're answering the question, were the responses sufficient, I guess?
So are you referring to?
Line 14.
So the response that Evergy provided to those 2 DR responses?
Yes.
Yes, because they directed me back to their direct testimony. And then also stated that it was not available by the billing cycle. So yes, I'm sorry, go ahead.
Go ahead. No, it's,
As it's been stated, that information, to the best of my knowledge, is available. It's just the delivery of that information. And so therefore, as a utility, I would think that they would also want to utilize that information and have that information available.
would you agree that data requests 69 and 140 are largely repetitive of data or the 2 sets of data we talked about, 2 and 3, that was noted on Mr. Lutz's schedule?
Somewhat. I would like to bring your attention, though, to it asking in detail of which rate codes that they could provide. So in the last rate case, for instance, we had net metering that was actually included into another rate code, and the ending of the rate case actually now has those as their separate rate code. So this is asking more in detail, which rate code, if any, can you give us? And then it goes on to ask about billing cycle. If you're not able to ask or to deliver it by rate code, can you get to bill cycle level? Is that an alternative? We don't know. This is just merely asking the company, what can you give us? And the response was, we can't.
So effectively, you're really asking, can you give us more detail on the answer you gave for 2 and 3?
By rate code, yes. Can you give us information? Which rate codes can you give it to us? Which ones can you not? Or can you at all? And the response was no.
Do those questions ask for data by billing cycle?
Can you, I'm sorry.
Do your 69 and 140, are you asking for data by billing cycle?
Yeah, as I just stated, that was an ask to see if that was available. We're looking, as we've talked about throughout this hearing, is alternative data. Yes, in the real world, what I would like is as much data as I could possibly have to make sure that these billing determinants and these rate revenues are correct, and that we're not just making an assumption of, well, it looks good, let's just go with that.
Well, that was an additional thing that wasn't included in the first 2 and 3, the sets of data 2 and 3, right?
You're correct.
Okay. That's all I have. Thank you very much.
Thank you. And it is time for bench and commissioner questions. I don't typically like to interrupt witness testimony. We are going to take a break now. Let's come back at 3:15. The timing just works out a little too perfect. We'll come back with Ms. Cox for commissioner and bench questions, recross, redirect, and then our last witness, Mr. Lubert. Okay, we're at recess, 3:15. Thank you. Thank you all. Time of recess having expired and the judge having arrived late. I appreciate your patience. Before we get to commissioner and bench questions, let's revisit Exhibit 213. I've had some time to reflect. I'd like to hear another round of arguments to give everyone a chance to weigh in. On the table is the admission of Exhibit 213. Has already been marked. It was previously rejected as an exhibit. Mr. Kleiser made a motion to reconsider, which was denied. The judge is going to bring up a motion to reconsider. So let's start with, I'll start with staff and we'll end with Mr. Fisher. Staff, tell me why Exhibit 213 should be admitted into evidence.
Thank you, Your Honor. At this stage, the exhibit has been referenced multiple times. I think that staff has made it clear that we at least are referencing this exhibit in terms of looking back at the data that we have received historically compared to the data that we are seeking in this case. There were also subjects brought up in Mr. Lutz's rebuttal that staff did not have the ability to rebut because of the timing of when those issues were brought up. And some of that goes to staff's role in looking at rate structure. And we believe that that goes back to that 1996 order.
Mr. Kleiser.
Not to repeat too much of what was just said, but the document has been referenced multiple times. I think at one point the witness stated something as this document speaks for itself. I feel like it would be imprudent to have the record have this interpretation of a document without the document available for the commission to draw its own conclusions based on. As a final point, I'll just stand on the fact that I believe the original objection was to relevance, and the standard for relevance is whether its value is more probative or prejudicial. I don't see how this document being entered into the record at this stage is prejudicial to any party, but it clearly has probative value.
Mr. Fisher.
I think we objected on the grounds that could have been added with the staff's rebuttal testimony, but Judge, in the spirit of cooperation, Evergy will withdraw its objection to it.
So admitted, Exhibit 213. Thank you. Let's move on to witness Kim Cox. We have commissioner and bench questions. Are there any commissioner questions? Chair Roop.
It's not a question, it's a comment. Congratulations on Employee of the Month for February. So,
Thank you.
so I just wanted to let everybody that didn't know that you're in the presence of greatness. So.
Thank you.
Thank you. Chairman, are there any other commissioner or bench questions? Any other commissioner questions? Hearing none, the bench does have just a couple. Check my list. What additional value is the billing cycle data when Evergy already provides rate code data for the first and last day of each month? Let me repeat that. If Evergy already provides rate code data for the first and last day of each month, rate code data, what additional value is the billing cycle data?
So are you referring to the DR asking if they have it at bill cycle level, or are you wanting to know what the value would be getting at on the hourly level?
Both.
As far as the hourly, like others have stated, with the high differential that we're gonna have, for me to do my analysis, I have to know where that usage is in order to apply the correct rates. I have to know, and Michael Stallman, when he was discussing the weather normalization, as of today, when he gives me the weather normalization factor, I apply that at rate class. And with what has been presented today, we're anticipating customers hopefully using their electric differently based off of what rate plan they're on. And so therefore, in order for me to calculate the revenues, I'm gonna need to know where that usage is falling. So at the rate code level, I hope I'm answering your question. And so bill cycle level, I haven't given it a great deal of thought because it was an alternative to what we originally asked for. And I would need to think about it in order to actually provide you a concrete answer.
Thank you. That was all that I had. That will take us to recross and redirect. Mr. Kleiser,
No questions, thank you, Your Honor.
Mr. Fisher,
No questions, thank you.
and redirect, Ms. Kerr.
Yes, I just have a couple questions. In response to the question Judge just asked, it sounded like the judge was under the impression that you currently receive customer counts by rate code for the first and the last days of each month. Currently in rate cases, does Evergy provide those costs for the first and last day of the month?
No, they do not. They give customer counts for the customers that were charged that month.
Okay. Do you know if bill cycle data is used for weather normalization?
Yes, it is.
Okay.
Yes.
And Mr. Fisher, okay, never mind. Should I ask that? I don't have any other questions. Thank you.
Thank you, Ms. Cox. You are excused from the stand, subject to a very short period of recall. And we'll get our next witness, Mr. Lubert, which, if I double check real quick, is our last witness. Is that correct?
Yes.
After we get done with Mr. Lubert, I'm going to go ahead and let the commissioners know that we'll be wrapping up just some items after that. But what we will be addressing is going to be the exhibits. We have at least 3 that I have notes on. I also want to run through each party's exhibit list to make sure I have everybody's exhibits that they offered and wanted on the record. Mr. Lubert, raise your right hand. Do you solemnly swear or affirm that you will tell the whole truth during your testimony?
Yes, I do.
Thank you, sir. Your witness.
Thank you. It's still afternoon. Good afternoon.
Good afternoon.
Could you please state your name for the record and spell your last name?
It's the letter J, Lubert, L-U-E-B-B-E-R-T.
And by whom are you employed and what's your position?
Employed by the Missouri Public Service Commission, part of staff, and I am the Tariff and Rate Design Manager.
And have you prepared and filed testimony in this proceeding, specifically your rebuttal testimony that was filed on December 15th, 2023, which has been marked as exhibit number 202?
Yes.
And do you have any changes or corrections to make to that document?
I don't believe so.
If I already asked you the same questions in that document today, would your answer be the same or substantially the same?
They would be substantially the same.
And are those same answers true and correct to the best of your knowledge and belief?
Yes.
And so I offer Exhibit 202 into evidence and tender the witness for cross.
Thank you. You've heard the motion. Are there any objections to the admission of Exhibit 202? Hearing none, it is so admitted. Witness has been tendered. Mr. Kleiser.
No questions, thank you, Your Honor.
Mr. Fisher.
Just briefly, Judge. Mr. Lubert, as the manager of the Tariff and Rate Design Department, do you set the policy objectives of that department?
Do I set the policy objectives of the department?
Yes.
I suppose that I have input, but I wouldn't say that that I would set objectives without input from others.
Okay. Well, would you do things like review and approve the testimony of the people in your department?
Absolutely.
And would you review and approve the data requests that are issued by your department in cases before the commission?
Most of them, yes.
Did you specifically review the 200 or so that were issued in this case?
I reviewed the data requests that were issued in this case.
Okay. Have you specifically directed your staff to prepare a distribution study for Evergy?
I have not specifically individually told staff to go and do that, no.
Would you have reviewed and approved the PowerPoint presentation that Ms. Lange presented to Evergy on August 9th regarding rate modernization?
I did review,
Objection, I don't think it was August 9th.
I'm sorry, did I say, what did August 28th?
you're talking about the PowerPoint presentation that you handed Ms. Lange earlier, correct?
Right.
I did review that.
Okay, and did you approve that as policy for the department?
I think that PowerPoint includes some disclaimer language. So it was part of a discussion as part of kind of a collaborative workshop discussion.
Okay. Would you have reviewed and approved the filing of the staff complaint about this particular case, data collection proceeding?
I believe at this point, staff hasn't provided testimony in the complaint docket.
That's correct.
So I have been involved in some discussions about the complaint.
And would you have approved
But
I'm sorry.
I'm
Go
sorry.
ahead.
At this point, I think the complaint was provided by an attorney, which I don't have. I'm not tasked with.
So you wouldn't have necessarily approved that filing?
I've been involved in the discussion. I understand why it's being filed, and obviously some of the issues that are raised within that docket are related to some of the dockets that
That you're,
staff within my department are involved in.
I think all of them are involving your department, right?
I'm going to object to this line of questioning. With the complaint is a separate case than this, and I don't know where we're going with this.
Judge, it involves the same exact data, the same exact requests that were part of this case.
It's
And
not part of this case. It's a separately docketed case.
Mr. Fisher, if you could continue, please.
All right. On page 4 of your rebuttal.
I'm sorry. I apologize. Ms. Kerr had cut you off, and I wanted to hear the rest of your answer to her objection.
Well, my concern is that staff complaint involves the basic allegations that were made in this same data retention case. It also involves allegations about the rate modernization discussions that have occurred, that we were not forthcoming, or that those need to be ordered. The commission needs to order us to do that. And I was just pursuing that line. It's certainly, they're directly related to this case.
Ms. Kerr?
Evergy's asking the commission to order the rate modernization. We aren't. Staff is not in this case.
Well, Judge, I think the testimony in this case is that the data is needed to evaluate not only Evergy's rate modernization proposals, but also the staff's, to assist it anyway.
I think that's a mischaracterization of the testimony that was been presented so far.
I think the same testimony has been characterized a couple different ways and could be interpreted a couple different ways. I'm going to overrule the objection for now. Mr. Fisher, let's quickly get to the point.
Okay, I won't take very long then. Well, Mr. Lirbert, you said you knew why that staff complaint was filed. I'd ask you, why was it?
I think what is included in the complaint is kind of self-explanatory.
He's asking him to make a legal conclusion as to what's in the complaint and why.
I'm with staff so far on this side. Mr. Fisher, what, do you have a response?
Yeah, I was following up on his question. He understood why the staff had filed that complaint.
I think that's still going towards the legal conclusion as to what the legal reason was for filing the complaint. But I don't think this witness is, I don't think this witness is capable of answering that question. And the reason why staff and its attorneys decided to file a case is attorney-client privilege.
Yes, I'm going to agree with staff on this.
Okay, I'll withdraw it. Thank you, Judge. On page 4 of your rebuttal testimony, you discuss information asymmetry. And on the line 20, you state, when the utility, in this case Evergy, indicates that the data or information cannot be provided because it is not retained in a manner that can be provided to the requesting party, this prohibits the other parties to fully undertake the required analysis. Is that right?
I think that's an accurate reread of my testimony.
Okay. Mr. Lubert, who decides what is the required analysis that needs to be performed?
I think the answer probably depends on the context. I think in this question and answer, I'm talking kind of broadly about asymmetric information. And this speaks generally to information that maybe is available to the company, but not being provided to another stakeholder based on, I guess, format.
Well, the required analysis that you're discussing means the analysis that a party wants to perform. Isn't that right?
It probably depends on the context.
If it's the required analysis some party wants to perform, irrespective of the cost or the parameters of creating the data or information. Wouldn't that be true?
I'm sorry, can you restate your question? And you're specifically asking about cost of
No,
provision of data?
I'm specifically asking about your testimony where you say that when a utility, in this case Evergy, indicates the data or information cannot be provided because it's not retained in a manner that can be provided to the requesting party, this prohibits the other parties to fully undertake, and the term is the required analysis. And I'm just trying to understand what is that required analysis and in this situation.
So specific to this case, the information that staff is looking for has been described, I think, very well by Ms. Laney. Her testimony describes well, not only within the context of this case, but her testimony in the last few rate cases has described some of the difficulties that she's had in getting information that would be necessary for her to undertake an analysis to provide a reasonable class cost of service study.
And we're talking in a broader context, I think, in your testimony about the theoretical asymmetric versus symmetric ability of other parties to access the information available to the utility, right?
I do think this question and answer is broader than that,
And so-
broader than the context of this case, but I think your question kind of narrowed that.
It did a little bit, but let me broaden it again. The required analysis in a case may not have been anything ordered by the commission, right?
There may be things that aren't explicitly ordered by the commission that would be required to do a reasonable analysis and provide information or a reasonable recommendation to the commission.
And the
Yes.
required analysis might not be relevant to the case, but some party thinks it would be helpful to their position. Isn't that right?
I think in the context of this case and the information that staff has been seeking, staff's opinion has been that the information sought is necessary to provide reasonable recommendations to the commission. I know that earlier you asked a specific question about cost and at what cost does that maybe become prohibitive. I think Ms. Lange testified earlier, and within our position statements, we've provided that our request wasn't ignoring the cost of being able to get some of this data that's been asked in the past.
Yeah, I appreciate that answer, and I'm trying to understand the symmetric versus asymmetric issue. Isn't the cost of creating and producing data and information for that required analysis that you're talking about an important factor in determining whether the data and information should be produced?
I do think that the cost of being able to produce information is an important factor. And I think that is consistent with staff's position in this case.
Yeah, and staff has now concluded that it would be imprudent to spend $80 to $100 million to get that data as data set number one.
I don't think that staff's position has ever been that it should take $80 to $100 million, or that we would recommend that the commission order Evergy to do that.
Is there anyone on staff that has the expertise to testify about what it would cost to modify computer systems and various systems to obtain that kind of data?
I don't have,
You sort of did us direct.
I don't have a computer science degree. Staff has a lot of employees with differing backgrounds, and with different expertise. I can't say with certainty that we don't have somebody that could estimate some cost of doing some database designs or redesigns, but that isn't I don't know, even though that's something that Evergy seems hung up on in this case and seems to be misinterpreting staff's position to the commission, that hasn't been the impetus from staff's point of view. Staff's been trying to obtain information that can reasonably be had at a reasonable cost in order to inform several different areas, a few of them being determining what appropriate revenue amounts are within the context of general rate cases, and then trying to understand pricing differentials that occur within Evergy's current tariffs and what we assume Evergy may propose going forward.
Is there any place in the staff's rebuttal that I should go to find what staff would view as the cost of producing that information? You didn't put anything in your rebuttal on that, did you?
Well, so our rebuttal is responsive to the company's direct testimony, which includes little to no cost estimates on individual cost components.
And staff's testimony doesn't have any at all, right?
I don't believe that staff
Objection. I think
has cost estimates included within its rebuttal testimony.
Okay,
no.
thank you, that's the question. Let me change roles with you. How would you describe your department's role in presenting tariff and rate design recommendations in cases before the commission?
How would I describe our role
Yes,
in presenting tariff and rate design recommendations in front of the commission?
yes.
That is the role of our department.
Okay. Let me ask you more specific questions then. Is it your role to evaluate the company's tariff and rate design proposals?
It is.
Is it your role to recommend improvements to the company's rate design proposals?
It is, and I'm if you're going to continue with questioning some questioning specific components, I do want to add a caveat that, among other things, yes, it is, because I don't want it to be limited to just that. My department deals with a lot of different cases, and I'm sure it shouldn't be a surprise that with a department name including tariffs and rate design, that we get pulled into a lot of different cases other than just a general rate case or a tariff filing.
Oh, sure, that's for sure, certain. I missed one of my questions, and I think it's an important one since you've been around the commission a long time. Is it your understanding, based upon your years of experience here at the commission, that public utilities and other parties are not expected in discovery to perform additional analysis where the data does not exist or where the analysis has not been previously performed?
Objection, speculation. Calling for speculation.
Mr. Fisher?
I'm not asking for speculation. I'm asking what his experiences is at the commission with regard to, in discovery, whether utilities are expected to do additional analysis or produce data that doesn't exist.
I agree. Objection overruled.
So I would say that probably one of the most common objections that we see to data requests from various companies is something along those lines.
And those are sustained.
I wouldn't say that for the most part the objections are. I don't want to give a number. I guess there are a lot of data requests within a slurry of cases that companies will object, kind of provide a blanket objection to. We'll use this case as an example. Nearly every single data request, but then provide some sort of answer.
Well, I'm just asking, most of the time utilities aren't required to produce stuff that doesn't exist, right?
So I think this is a really interesting question. I'm glad that you asked it. I think this is part of the reason that we're here today. What we're hearing from the company is that you have information available, but it isn't in a format that is useful or that you can't provide it to staff.
At a reasonable cost.
I,
Question.
Objection. He's testifying.
I'm asking, well, okay, I'll withdraw that.
so
Let me ask you this question. In the context of discovery, not, the commission can order the utility can do a lot of things, but in the context of discovery, wouldn't you agree that based on what you've seen, most of the time utilities aren't required to produce things that don't exist?
I'm going to object. I think he's asking for a legal conclusion here.
There's nothing legal about that. It's just, are utilities asked to, or produce information that doesn't exist in discovery?
I understand that it could be construed as a legal question. However, I know that it was brought up in the discovery conference, and it certainly has been an underlying issue in this case. I'm going to go ahead and allow it. As far as Mr. Lubert's opinion goes, the commissioners can take that and interpret that on their own.
So I think something that is regularly becoming an issue is that staff is asking for information from, I'll use Evergy as an example because we're here today.
I think I asked you a yes or no question on that. Can you answer it, yes or no?
Could you re-ask the question? I'm sorry.
Yeah. Rather than have Bev read it back, isn't it true that in discovery, utilities are not typically asked to produce things that don't exist?
I think so for the most part.
Okay, thank you. Moving right along. Is it staff's role, in your opinion, to recommend rate design proposals that are fundamentally different from those proposed by the company?
Objection, relevance.
One of the issues in this case is the role of staff in presenting rate design proposals, and we're asking for guidance from the commission on how that should go forward, and that goes directly to that question, Judge.
I think the issues in this case is whether Evergy is able to provide the data and how much it's going to cost if they don't have the data, not rate design. This isn't a rate case.
The parties were not able to agree on the issues, so the commissioners will have to determine what the issues are in the case. Right now, Mr. Fisher and Evergy have presented a question as an issue to the commission. Please give us guidance on how rate
Design.
should be moving forward. I paraphrase terribly. In order to allow Evergy to develop that issue with testimony and evidence, I'm going to allow the question while acknowledging that this may never end up being an issue in this case.
Understand.
Mr. Fisher, go ahead.
I think the question was, is it the staff's role, in your opinion, to recommend rate design proposals that are fundamentally different from those proposed by the company?
So within the context of a general rate case, staff conducts an independent audit proposes, we filed direct testimony proposing what our recommended level of rate increase is, as well as providing direct testimony based on class cost of service and rate design. The other interveners within the rate cases that I've been a part of have included recommendations on rate design that aren't necessarily exactly tied to what the company has proposed. I don't think that making recommendations on rate design that may be independent of exactly what Evergy is proposing is anything new.
Would you agree that it's not the role of the staff to manage the business of the public utility?
Objection, its relevance.
Mr.
And
Fisher?
It's the same topic, Judge, the role of the staff in presenting rate design testimony. And if you recall in my opening, I did make a point of that.
Yes, but this question is about managing the business.
Correct. It's the role of the staff is what I'm asking about, is the role of the staff to manage the business.
I am going to side with Ms. Kerr on this. This does seem to go at least a toe over the line there.
Okay. Well, when you're making recommendations to the commission that are fundamentally different from the company on rate design, how do you decide that it's not stepping into the role of management of the utility?
objection, I think this is the same question, just asked a different way, so object is relevance.
I gotta say, because of the rewording, I now see the question in a slightly different light. Mr. Fisher, can you respond to the objection?
Yeah, Your Honor, one of the issues is, at what point does the staff have the ability to make independent recommendations to the commission that require the utility to create and do analysis in order to make those recommendations? That's the fundamental reason that in some instances, the utility would be asked to do analysis and prepare data that doesn't exist so that they can make an independent recommendation. And that's where this is going.
I'm following all of that, but you tied it to business practices, and that's where I'm on the fence, because on the one hand, I could see in Evergy's favor ruling on this, because at some point, coming up with a rate design might get to that high level of managing a business, which makes me regret my previous ruling. But on the other hand, I don't know if that's really where you're going.
Well, if it's not clear to the judge, I'll move along there. We can move this along here.
Okay, thank you.
Let me go to some other roles of the staff. Is it the role of the commission staff to be fair, objective, and unbiased, in your opinion?
I think that commission staff does strive to be fair, objective, and unbiased. I do think that there are times that we are provided direction that we need to provide an assessment on with kind of in certain light. But generally, those are three things that we do strive for.
Is it the role of the commission staff to be a strong and aggressive protector of the ratepayer interests?
Yeah,
Objection. Where are we relevance, where are we going with this?
Okay. Your objection is relevance?
And legal conclusion?
Mr. Fisher, you have a response?
Again, it's going to the role of the staff in presenting testimony in front of the commission on rate design and developing, and the requirement to have the utility prepare an analysis and create data that doesn't exist. I'm just asking what is his view as the director of the tariff division? What is his view of the role of staff here? That's what I'm asking.
I don't think that was the question asked, though.
Is it the role of the commission staff to be a strong and aggressive protector of the ratepayer interests?
A strong and protective,
It's all, I also object as it being vague, and
I was going to go with the vague.
I'm not exactly sure what he's asking.
Okay, well, let me ask something more specific then, Judge. I'm sorry if I'm being vague. From your perspective, is it the role of the commission staff to present a case that's intended to keep the rates of residential customers as low as reasonably possible within the confines of the law?
Objection. This is- I'll withdraw that.
Mr. Lubert?
Your question is I guess, could you restate your question? I was writing and I'm not sure that I got all of it.
Yeah, from your perspective as the department head, is it the role of the commission staff to present a case that's intended to keep the rates of the residential consumers as low as reasonably possible within the confines of the law?
I don't think that is necessarily the role.
Is it the role of the commission staff to make recommendations in a rate case that are designed to keep the public utility financially healthy?
It's the role of commission staff to provide recommendations that are reasonable based on facts and information that are available. In this case, we're talking about information that isn't available and is making it difficult for us to make recommendations on the reasonability of what the studies are or what the rate differentials are. That's really why we're here. We're trying to get some sort of, trying to get some information that will give some sort of clarity on some of those rate differentials, and then making sure that we can have information available to us during the next rate case or a rate case a year from now or 2 years from now that allows us to do studies to make sure that we are making adjustments that are in line with what the data tells us.
Well, do you disagree that it's the role of the staff to make recommendations in rate cases that are designed to keep the public utility financially healthy?
I don't disagree with that, no.
Okay. When you're making those recommendations, do you try to have your department follow policies that were established by the commissioners through previous orders?
Objection, vague, relevance. What does he mean by policy? Where are we going with this? There's so much.
Thank you, Ms. Kerr. The objection that I heard was relevance
Vagueness.
and vagueness. Mr. Fisher?
Well, I think the question's pretty specific, but if you don't want me to ask it, I'll withdraw it.
I'm not saying anything. They objected.
I think it's quite specific.
Okay. And the question was, do you follow the policies interpreting those from previous commission decisions?
That's correct.
What does he mean by policy?
Can you clarify policy or reword the question?
When the commission issues an order, do you try to follow it?
Staff does follow commission orders, yes. We also try to bring to the commission's attention when companies may not follow those orders.
How would you decide when staff should advocate a position that differs substantially from a past order?
objection is asking for speculation and for him to make a decision on what staff would do generally. He can't make a decision on that. It's asking for him to make a conclusion, legal conclusion.
Judge, this is the director or the manager of the Tariff and Rate Design Department, and he, I think, at least has a role in setting the objectives of the department. And I'm asking, whenever they decide to advocate something that is different from the policies that might have been established in a previous order, how did they decide to do that?
I'm going to need an example.
Okay. For example, if you have a commission that's issued a rate design order that has residential, small general, large general, and industrial classes, if you were going to make a decision to get rid of the customer service or the customer classes, what would cause you to do something like that?
He's asking for a hypothetical.
So staff wouldn't be able to just remove those class distinctions in and of itself.
Would staff be able?
Company-
Okay, I'm sorry.
Sorry.
I didn't mean to interrupt.
No, and I'm sorry, I didn't mean to cut off your question.
For example, if the staff recommended a continuous rate design proposal, which is different from what we have today, what would cause you to make a decision to recommend that kind of a proposal as a path to the future?
So
Are we talking hypotheticals here?
The question's on the table.
I know, and is that an objection?
Sure, yes. I mean, if it's just hypothetical, I mean, are these fact, my objection would be facts not in evidence, but
I have occasionally helped various parties with questions in the interest of getting information to the commissioners. I'm going to try that now without unduly imposing, hopefully. So, Mr. Fisher, if I get it wrong, speak up. Counsel, feel free to object or speak up. I think the question is when or how did staff decide to move to rate modernization or start rate modernization? Is that where we're going? If we could,
That's a fair question, Judge, yes. That's a good roadmap for a path forward on this question, yes.
I'm sorry, just
I
really
don't-
quick, on the question that you just posed, is the commission presupposing that staff has made a determination on how to proceed at this stage?
yeah, I'm struggling with the wording because Mr. Kleiser's right. My question does that. I don't want to presuppose that, which I think is where I think a lot of the objections were coming on the question, and I'm trying to help out so we can just get the question. Maybe what caused staff to feel that a prior rate making scenario should be updated?
Yeah, I think, Judge, you asked me to give an example, and the example that I was asking was if we have a current existing rate structure, what would cause staff to decide to go to a continuous rate structure proposal?
I don't think we've,
Is this a continuous rate structure proposal?
It's in the rate modernization plan.
but
Okay, but
that's not in evidence.
Yeah, we're talking about the data requests. While rate modernization is certainly maybe a portion and might be driving some of this. I'm not sure that that particular question is going to be relevant.
I will withdraw the question, Judge.
Okay,
And to
thank you.
move this thing along, I think I've asked the questions I need to ask, I guess. As an engineer, though, Mr. Lubert, one last question. You understand that creating and producing data in a complex information system may not be just as easy as pressing a button or hiring a new computer programmer, right?
That's certainly possible. Yeah.
That's all I have, Judge. I'm sorry to belabor the cross here.
That's okay. Thank you, Mr. Fisher. That'll take us to commissioner questions. Are there any commissioner questions for Mr. Lubert? We'll give a second for those on WebEx. Hearing none, the the bench does have just one. I'm referencing page 4
Of my testimony.
of your rebuttal, yes. Your testimony had recommended that the commission order Evergy, that Evergy ensure access to actual hourly customer load data by rate code and ensure access to accurate customer counts by rate code. And that access would, if it was timely, would avoid months of regulatory lag when processing rate cases. Here's my question. Would Evergy providing that information through monthly non-case related submissions into EFIS, if Evergy filed the information that you asked for in monthly non-case related submissions into EFIS, would that eliminate that issue?
So I guess I want to, if I can, just clarify a little bit. The list of items, I was trying to read page 4 and see, I think they're maybe on another page, but it didn't sound like it was misquoted or anything. But I think Evergy brought up this concept at some point that, you know, staff may be seeking kind of like this untethered access to their systems, and that's really not what we're looking for. With some of the customer and usage information, and Ms. Lange talked about it, and I think Ms. Cox also talked about it. We really need that information within the context of general rate cases, but it happens multiple times within the context of those cases. So Evergy typically sets a test year. Staff will usually recommend an update period, which kind of gets information more current. Ideally, we'd like to get that information as current as we can, while also providing us with time to be able to do our analysis, make our recommendations, discuss internally, have, you know, testimony drafted and reviewed. So kind of the ability to get that information up to date in a relatively short amount of time would be important, or at least would reduce some of that lag going forward, because it would allow us to push our update period further in time or closer to real time. Some of that information is also needed for the true-up period, that having that true-up period, having the information for the true-up period in a shorter time frame would also be helpful. I think I brought up a couple other instances where some of this information, and maybe Ms. Lange does too, but for within the context of some of the MIA filings, this may be helpful information as well. But it isn't something that I necessarily think staff needs or wants monthly, every single month from now until the end of time or something. But we do need the information, and it needs to be able to be provided in a timely fashion. So that when I'm talking about that information, I'm specifically talking about customer count, customer usage by hour, that type of information. Some of the information that's included, I think, as we were talking about it, I know there's been trying to make that clarification, but in the term referenced, term 1 referenced in the stipulation and agreement, some of that information obviously doesn't need to be provided monthly, but I think Ms. Lange talks about the importance of being able to go and look at what that cost information looks like over time. And the fact that some of that data has not been updated in a very long time, and we're just due to do so. I'm sorry, does that answer your question?
Yes, thank you.
I think the short answer is we wouldn't necessarily have to have it monthly. We need the information relatively quickly in time periods that we do need it.
In the interest of finding common ground, I just want to clarify timeliness. I thought that the testimony established that 18 months back from the beginning of a rate case is when the data that you get usually starts. And that's why by the time we get to the rate case, it was untimely. Is that a fair statement?
I think that when you're talking about the 18 months back, saying I think thinking of the last few Evergy cases that I've been involved in, I think test years that are roughly kind of on a 6-month lag from when they file. I think that is roughly accurate. We have had issues getting information for update periods, and that is not something that probably has a lot of testimony in front of the commission, because generally some of those discussions are occurring within the context of trying to set the procedural schedule. And so as we're doing that, we're trying to look at what is the date that you can reasonably provide us information for month X. And that month X may need to shift in order to allow us time to review and provide recommendations for that update period.
And I'm sorry, I should have just asked what I meant to ask. Out of the timeliness discussion, am I hearing correctly that moving the data from Evergy up a couple months is the timeliness issue? So instead of 18 months, if it was 16 or 15, if the same with the update period, if it was just, are we talking just a little sooner? I don't want to put you on the spot to pick a number. I'm trying to see if there was some.
I do think that that the availability for information that is closer to the time of our direct filing has been more difficult, or I guess the data has been staler, I'm not sure if that's a term, more stale, with Evergy in the past few rate cases than other companies been able to provide.
Okay, thank you. That's all the questions I have. I have taken too long. I will ask again if any commissioner questions. If any commissioners have any questions, it is *6 to unmute for commissioners on WebEx. Hearing none, we'll go back to re-cross-examination. Mr. Kleiser?
Very quickly, you were asked a question regarding page 4 of your testimony, lines 5 through, I think, 7, roughly. Specifically, you were asked about whether the access to actual hourly customer load data by rate code, and then accurate customer counts by rate code. That was just occurred. You recall that discussion?
I do.
Would you agree with me that a company that had AMI deployment should be able to achieve actual hourly customer load data by rate code?
I would expect that to be the case. Yeah, that is one of the benefits of that have been touted for AMI is the ability to have this hourly information. I do know that you know, Evergy's obviously had their AMI meters in place longer than the other utilities, or at least the electric utilities within the state. I know that they've talked about some of the capabilities that could happen with the AMI for quite some time within the rate cases that I've been a part of.
And I apologize, just for the sake of the record, I know it was addressed earlier, AMI, we are both discussing advanced metering infrastructure, correct?
Correct.
And then again, just to reiterate one more time, the accurate customer counts by rate code, that is also information that you would agree with me, a company that has made substantial AMI investments should be capable of generating with relative ease.
I would certainly hope so, and I would think that that's information that the company would want to keep as well.
And again, just for the sake of the record, I think you might have mentioned this earlier, you would agree with me that Evergy has substantially completed its AMI deployment for residential customers.
I believe so.
No further questions, thank you.
And the company?
No, thank you.
And redirect.
Yes, I just have a few questions. Thank you. Excuse me. Mr. Fisher asked if it's staff's role to evaluate tariff rate design. Do some of our departments cover some other tariffs?
Is the question, are there other departments that cover other
Tariffs.
tariffs? Yes, there are.
And so you're not doing all the tariffs?
No, we're not.
Okay. And you were also asked about doing analysis. Is it your experience that different utilities have different views on what constitutes analysis?
Absolutely.
Can you expand on that?
Yeah, so one of the issues when we're talking about some of the data requests, one of the issues that we've run into, and at least in recent history, and maybe this has been the case that I'm not aware of in the past, but in recent history, what we've had are these objections to data requests for from the company saying that would require us to do additional analysis. I touch on this a little bit in my testimony, but to the extent that it would require somebody at Evergy to do something to get information isn't exactly the same as creation of data, right? So when Evergy is talking about the fact that information is available, but they just can't give it to us, or they won't give us the information because they say it's not in a useful format, that can be problematic. Especially when we're talking about some of the hourly information that we expect to be available, and when we hear from other utilities that this information is going to be available, or they're not really sure why we wouldn't think it would be, that becomes problematic. And so I talk about within my testimony this the potential for, or I guess a risk of a utility kind of setting up barriers that withhold information. That's something that we obviously don't want to have as an issue going forward.
And you had those issues with Evergy in this case? I mean, did you run into some of those issues with this case?
I think in this case, the issue that we had with the DR responses most of the time was referencing back to their direct testimony that included very little, if any, information, especially around the costing. We've had the issue that I've described in past cases, though.
Okay. And you were discussing data availability versus deliverability, and whether that was requiring a utility to, quote, produce information that doesn't exist. Is asking for delivery of information asking for information that doesn't exist?
I don't believe so, no.
So what would,
Specifically, so within the context of a rate case, well, we've been told that Evergy is doing some, I don't want to use the wrong phrase, but I want to say data cleanup for filing its direct case. And then when we've asked for essentially the same information for the update period, we've had pushback stating that that would require additional analysis that they weren't willing to do. Now, the result has been that the company, in some instances, has done that analysis for themselves, but only to the extent that they wanted to respond to staff. And so they do the analysis. They refuse to give us the information that we request, but they'll do an analysis very similar to what we've asked for, or very similar to what they've done for their test year, in order to respond to our direct or our rebuttal testimony. That's a barrier that really shouldn't be in place.
okay, and in the context of an update period, is a month a long time? And how so? If it is.
A month can be a long time, especially depending on the timing. So when you're looking at some of the differences within rate structures, there are differences in the rates that occur within a season, and to the extent that that month pushes into a season, that can make a difference. What we're looking at for this next rate case, a month means another month of information with customers that have been served under the new higher differential time of use rates. From what I understand from the data request responses and some of the testimony in the hearing room over the last couple of days, Evergy's upcoming rate case, their test year is unlikely to have any information regarding customers being served on this higher differential. To the extent that we don't get information within our update period for that transition, that starts to become, basically that entire issue becomes a true-up issue. That's problematic because the timing becomes much shorter, and just the level of the amount of time that we have to review and develop positions and provide the commission with recommendations in that case makes it much more difficult. So the short answer, I think, is yes, a month can make a lot of difference. 2 months can make even more difference when we're talking about a transition time period like we're in right now, where with a company that's expecting to file a rate case any day.
Excuse me. And you were asked whether staff made a cost recommendation in regards to the data requested. Does staff have the information regarding Evergy's systems to even begin a cost study?
We don't. The purpose of, well, one of the reasons that we are here today is that we were asking for, we signed a stipulation and agreement with the company. We're trying to get an idea of what some of these cost estimates were. What we thought we'd get in direct testimony from the company were breakouts of here's what it'll cost for component X, Y, and Z. Component A, B, and C are far too costly, and the accounts haven't changed that much, so maybe it doesn't make sense to do a deep dive analysis on that. What we got is the entirety of stipulation provision 1, a very high level estimate of what it would cost to redo their entire system according to them, and the company basically saying, that's what staff wanted in the first place. That's not the case.
Okay, so now under section 393.1401, the commission has the power to require utilities to to quote, prescribe the form of every schedule and from time to time prescribe or order such changes in the form thereof as may deem wise. Basically, well, let me try to paraphrase that. Set rates. Basically set rates. Just as to approach providing this document to that question. Okay. All right, might just be easier if I just hit, provide the statute to the witness and just ask my question. If I could approach. Now, looking at that statute, why would staff recommend a different rate design than the company? And how, I guess I can't. How does more than one independent study or recommendation benefit the ultimate decision in this case?
Before the answer, pardon, I missed it. Which statute is this?
Which one was it? I didn't write it down.
393, 140.11.
Sub 11.
Please continue. Sorry for the interruption.
Sorry.
Do you mind if I read this really quick?
Sure, go ahead.
Okay. And your question was,
Why would staff recommend a different rate design than the company? How does more than one independent study recommendation benefit the ultimate decision in this case?
sure, so, I mean, I think an important function of staff is providing the commission with an independent review, right? And so to the extent that rates are, if a rate design by the company isn't based on cost causation, it's probably a good idea to have an independent option to look at that might provide that as an option for the commission to order.
I don't have any other questions. Thank you.
Thank you. That ends redirect. That ends our witnesses. Mr. Lubert, you are excused and you are not subject to recall. Thank you.
Thank you. It's one benefit of going last, huh?
Commissioners, for your information, we're going to, me and the council are going to stay on the record and finish up some details here. It'll take about 5 or 10 minutes, but the substantive part of the hearing is over. Chairman Root.
Thank you, Judge. Appreciate everybody's time. What I'm going to say now is the opinion of Scott Roop, individual commissioner, not representing the commission or any other commissioners. But from my standpoint, the entirety of the last 2 days has been miscommunication, or poor communication. And this is now the second hearing that we've had in the last couple months, or a month or two, that the result of why we are here is because of poor communication. I think of the man hours, the time, the effort, the money spent on these hearings. You all, I'm talking to the company and the staff, you have better information and better data than the commissioners do. We will make this decision. But it's like asking the Congress to figure out a local zoning issue. We don't have as much closeness to it as you guys. But we will have to make this decision on what happened unless the parties can get together and come up with some type of a path forward, some type of settlement or something. Because you can always roll the dice and just see how it's going to turn out and what we're going to come down on. But I highly encourage you, since you have better information than we do, to try to figure out a path forward. So, again, that's just my personal comments. Thank you, Judge. Appreciate it.
Thank you, Chairman. Okay, let's get started. First, Ms. Lange, my apologies to you. I came down on you a little too hard during your testimony. I thought that I had, speaking of miscommunications, I thought your testimony had changed, had differed, and I obviously misheard. My apologies. Let's get to exhibits. I'm going to first read off, we have 4 pending exhibits that are, we have 4 pending exhibits. I'm going to talk about the first 2. These are going to be the late filed exhibits unless I get no objections here. I'm not pushing for no objections. I'm just letting you know that these 2 would fall into that category. First is Exhibit 219, which is in my hand. This is the commission requested attachment A to the motion to compel. Are there any objections to the admission of Exhibit 219, which the commission requested, it is staff's number, of attachment A?
No objection, Judge.
Excellent. No objection, so admitted. Exhibit 6 is the company's errata sheet filed last night, well before their deadline of 8 o'clock this morning, for Mr. Lutz's testimony. First, has council had an opportunity to be on EFIS to look at purported Exhibit 6?
Yes.
Any objections?
I defer to staff. Start. Go ahead.
Well, staff still believes this is improper rebuttal, but, you know, I think it's better to have the information than not have the information. So we'll withdraw our objection, but, you know, still want to say that it is improper rebuttal. I guess still want to have that on the record.
I believe your message has been heard.
I am torn because I would also like to maintain the objection because I think it is improper, but for the same reasons, I am willing to concede on the point, but I would echo staff's comments.
I applaud you for both taking the higher road. Exhibit admitted. Gosh, darn it, I keep misplacing my stickies. Okay, Exhibit 206, which is Miss Lange's direct testimony from previous rate case 0129 and 0130. We were holding that exhibit because what was offered by staff was the entirety of Ms. Lange's direct testimony. I believe the question, I don't know if it was an objection, but I believe the question that caused us to just put a pause on this was, do we want all of the pages included in this exhibit? Or only the 61 to 64, or only the, I think it was the class cost of studies section that preceded part of that. I'm going to start with Mr. Fisher first. Do you have any updated comments on Exhibit 206?
I don't have any real updated comments. I would still suggest that we have an excerpt that relates directly to this case, the cost of service stuff.
I do like a good excerpt. Mr. Kleiser.
I hate to be the problem child, but my preference would be to have the complete document under the rule of completeness. My rationale for that is simply that I don't want any party to cite to something out of context, and I just don't see what the prejudicial value of having the whole document is from an evidentiary standpoint, or for a cost standpoint from the commission for that matter. I don't have a strong opinion on this, but it's easier when you have the full context to make sure nothing can be misread. That's my personal opinion.
I can share my concern. My concern was, we're only talking about page 61 to 64. That was the request. But then we had testimony saying, well, this class cost of service discussion played into that. I'm now a little bit more inclined to let the whole shebang in.
And Your Honor, we actually do refer to more than just that. That particular portion is what is the highlight of this case, but I will say that I believe that there is more in the testimony in regards to this case, and I will echo Mr. Kleiser that for the sake of eliminating context in some way, I think it's beneficial to have the entirety of the testimony in the record.
My other concern is that there's going to be a citation to a portion of Ms. Lange's testimony from a prior rate case that we never discussed in this room.
Might I offer a solution?
Let's,
I mean, I think if somehow something is cited in a brief that someone has an opposition to, they could certainly file a motion to strike. I mean, I'm not trying to delay the case, but I mean, I can tell you that we don't intend to cite two elements.
thank you.
Okay.
Anything else? Excellent. If Evergy had an objection, it is overruled. Exhibit 206 is admitted onto the record.
In its entirety?
In its entirety, yes. Exhibits 3 and 4, I believe, were Mr. Lutz's, yes. We were holding those until 9:05 this morning to allow everyone to look at Exhibit 6, which is the correction. Are there any objections to the admission of 3 and 4, Mr. Lutz's direct and sur rebuttal? I didn't catch that.
No.
Well, staff's trying to say it wants to maintain its existing motion to strike for the purpose of the record, I think is what the point is, even though it was overruled for.
Motion to strike of his specific,
Yes.
Mm.
I mean, you had previously ruled on it, but they're maintaining it for the sake of the record is what I
Okay.
think they're doing.
I mean,
You want to make your motion?
I would suggest taking up the motion to strike with the case, but otherwise,
Okay.
with that objection, or with that motion, I would
This was your motion to strike all of Riley's testimony and like two
Portion of-
sentences of Mr. Lutz's?
Yes.
Judge, it was my understanding you'd ruled on that.
Yeah, yeah.
On
Are you
Mr.
preserving it for,
For purposes of the additional issue that Evergy has interjected, staff is renewing its motion to strike for the improper surrebuttal of Mr. Lutz.
Oh, for the love of God. I'll renew staff's motion to strike at the OPC because I want it on the record in the very small chance that I feel I need to bring an appeal.
okay,
So for the sake of the record, I renew the motion to strike.
okay. I want to make sure that OPC, you are,
Whatever the original filed motion to strike, the OPC joins it.
And on behalf of the company, again, I will object to that and suggest that it should not be approved.
thank you. Are you going to get what you need if I rule on that now? Yes. Okay, I'm going to stay consistent with the ruling given at the beginning of the case. Mr. Lutz's couple sentences are, the objection is, the motion to strike those couple sentences is denied as they asked a question and the commissioners can interpret that as they will, even though one of those questions was seeking advice. On Mr. Riley's testimony, that the objection was that it was not part of the underlying case in chief of the company, and in my ruling found that it was, was not persuaded by staff's argument, and it was, the motion to strike was denied.
And I would,
Go ahead.
I'd like to preserve that as well. No? Okay. Never mind.
Okay. Exhibits 4 and 5 are admitted onto the hearing record. Okay, one whole sticky is done. I'm going to go through now the parties' exhibit list. I just am double checking to make sure that all of your exhibits have been appropriately entered or ruled on. Let's start with the company. I have exhibits 1 through 7. 1 through 5 were pre-submitted. 6 is the Lutz errata sheet. 7 is the rate modernization presentation. All of those have been admitted. I'm looking to see if anyone disagrees. I hear none. I'm going to go with OPC because their list is shorter. 300 for Dr. Mark, 301 for DR1, 302 for DR2, 303 for DR3, 304C for DR2000. Note under the commission rules, we will have a blank public. And Exhibit 305, the commission response to EW, or the commission response that was filed in EW-2017-0245. Yes,
Really,
Mr. Yes.
really quick, you had previously indicated that you did want the OPC to update 300 to remove the confidential designators. You had mentioned at the time that an email was sufficient. I am prepared to late file. Judging by your gesture, I indicate that I am still supposed to email it to you. Is that accurate?
I'm gonna look to the other parties. I am satisfied simply receiving an email from Mr. Kleiser with the confidential designations removed from Dr. Mark's testimony. Would any other party like to look at that? Because it is going to be a substitute.
I would appreciate receiving a copy. I don't see it, need to see it ahead of time if that's all they do.
That's fine.
I will email it to all parties as a matter of course. Thank you.
Excellent, thank you. Staff exhibit list. I'm just going to go through one at a time. 200 is a rebuttal of Cox. 201 is the public, there's no confidential version. And 201 is the public version of Lange rebuttal. I'm going to stop here. Ms. Kerr, can you follow the same example for emailing the non-confidential, watermark stuff removed? Thank you. 202 is Lubert rebuttal. 203, Stallman rebuttal. Here are the ones introduced during the hearing. 204 is a stipulation and, that's the stipulation and requested data, a shorthand. 205 is DR 0250.1. 206 is the full Lange direct from file number 0129 and 0130. 207 is DR 0176. 208 is DR 177. 209 is DR 197. 210 is 213, DR 213. 211, is the rebuttal, also marked as Exhibit 50. 212 are tariff sheets. 213 is the order approving stipulation and agreement from EO-94-199. Exhibit 214 is rate codes. Exhibit 215 is the report and order from Ameren's prior rate case ending in 0337. Exhibit 216 is DR 206. Exhibit 217 is DR 207. Exhibit 218 is misnumbered due to the judge miscounting. Exhibit 219 is attachment A to the motion to compel. Those are all the exhibits I have. I've heard no input on exhibits. Mr. Kleiser.
Just a note, Exhibit 211 is designated confidential as well, for the sake of the record.
Is that the Lutz testimony? Okay.
As I recall, it was marked Exhibit 50, and it was from a prior case, but I don't remember the number off the top of my head. Yes, it's Lutz's testimony.
From the ER 129 case, right?
Okay.
His rebuttal of my direct notice.
Okay. Late file, we don't have any late filed exhibits. I order public counsel and staff counsel to email as earlier described 1 week. Today is the 31st, a Wednesday. Next Wednesday will be the due date. February 7th. I will put this all in writing in the next day or two. February 7th for the mailing of the non-confidential, previously filed exhibits. Okay, let's talk about briefs. Initial briefs already ordered February 29th.
Your Honor, can I have just one moment to confer with counsel for just a second regarding the briefing schedule? I have, if what I'm about to propose would work, it would be for the benefit of the commission. If you can give me just,
I'm gonna pause you for just a second, because I also want to make an announcement about settlement.
okay.
So the briefing schedule is February 29th and March 15th. As the chairman indicated, settlement can still be achieved by the parties. All kinds of different motions could be filed by the parties. And I am aware, because I was the judge in at least one prior case, which after hearing did settle. Mr. Kleiser, go ahead. You wanted to have a conversation. Let's go off the record for just 2 minutes.
We'll extend it.
Thank you. We are back on the record. Council was just discussing possibly changing some scheduling. My understanding is we are not going to change the scheduling at this time, but we will keep an eye for any filings to that effect in the future. Excellent. I don't have anything else. Does anybody else have anything they want to bring up? It is just a few minutes before 5. Oh, Commissioner Kolkmeyer, thank you. Commissioner Kolkmeyer, you wanted to say some comments. Please go ahead.
Yes, thank you, Judge. I just want to echo the chairman's comments here a little bit ago about communication. I think he was spot on. So I suggest all parties listen to what he had to say. So thank you, Mr. Chairman, for your comments.
Thank you, Commissioner. Your words have been heard by the parties. I appreciate that. Any other announcements before we adjourn? Excellent. We are adjourned. Thank you. We're off the record.
Thank you, Judge.